May I, may I, Lordship? Uh, Lordship, I beg to mention item number 32. I'm for the appellant, behalf of D. Majumdar.
D. Majumdar is
He's out of station, and due to some domestic problem, he cannot appear today. So the matter
item
may,
number 32.
yes. So the matter may be fixed on 12th of this month.
Yes, have you informed the additional PP and all?
Yes, I have already informed.
You are appearing for the response number 2.
Yes, Your Honor.
Your good name?
T. Tamo.
T. Tabo.
TAMO.
Heard Mr. T. Tabo, the learned counsel appearing on behalf of Mr. D. Majumdar, the engaged counsel for the appellant, and plead for an adjournment stating that due to personal inconvenience, Mr. Majumdar is not in a position to appear before the court today. Other side raised no objection. Please the matter accordingly. On 12th, you are saying?
Yes.
Many matters has been listed, I think, na 12.
I don't know.
Can it be?
Yes, Lordship.
Okay, then.
Yes.
12.
Much obliged.
12 of this month, na, you are saying?
Yes.
My lord, I beg to mention item number 24 and 25, my lord. My lord, leading counsel PJ Sekia could not come to them, my lord. So, my lord, this matter may be listed on next available DB, my lord.
Have you informed the other side?
No, my lord.
Then you should inform. Is appearing for the other side in 24 and 25? You want
Yes, my lord. Informed, other side is informed, my lord.
24.
24.
You are appearing for 24.
24 and 25 you are mentioning.
Yes,
Yes, 24 and 25. Mr. Navam is also appearing here.
Yes, but I'm there in the 25 Malat.
25.
24 and 25 is same method.
same.
Similar matter. No.
Few alag-alag deh rahe, I don't
That's
know.
connected matter. 24 and
It's a
25.
connected
Yes,
Malat.
Yes, connected.
But now this Malat item number 25,
Hmm.
I don't know, they have filed a condemnation of delay Malat in appeal. Whether that was allowed or not,
Okay, just let me see.
Well-
25 to deposit.
you are not there. I think I should be there.
I is not here. I
I
don't know
think-
whether maybe dispose.
I should be there, Malat. So far I remember last time also Malat that condemnation was not allowed, Malat. So that was,
Okay.
I'm not sure, Malat.
Just tell us in item number 24. I don't know, these are maybe connected matter. But item number 24, Mr. PJ Sakia's name is there.
Yeah,
Otherwise,
item number 24, Malat, there is no
25
problem. but
R Sakia.
That's Saika, yes. So
Are you appealing for both 24 and 25?
Yes, I am in both the cases.
both.
बोथ मैथ्स हिंदू का 25 में आई एफ फाइल किया था condemnation को।
वो एलो के
मतलब क्या है तो बता दो ना।
हमको भी मालूम है।
Yeah, whether I is there.
I'm sorry, my lord, that I had been allowed. One. Just my friend is informed. I'm sorry, my
I
lord.
is allowed.
Allowed, my lord. Then, my lord, no problem, my lord.
I is already there.
सबके लिए कर रहे हैं वही। अच्छा,
You are Mr.
L no C.
L?
No C.
L no C. 24 and 25 apply for heard Mr.
Hmm.
L no C appearing on behalf of Mr. PJ Sakia, the running and guest counsel for the appellant, and also heard Mr. R.H. Nabam, the learned additional AG appearing for the state respondents. It is submitted by Mr. Tosi that due to some personal inconvenience, Mr. Sakia, the learned and guest counsel for the appellant, is not in a position to appear before the court today and hence bid for an adjournment. Prayer allowed. Yes, what are you saying? Did you convenient date will be your
My lord, next available DB, my lord.
next available date?
Give me back.
Maybe this week, I mean, maybe next week also.
Maybe next week, this week, 2
We
days
don't
only.
know, huh?
Yeah.
So,
My lord, your lordship may not fix any that because all are local council, my lord. So next available DV is next week, my lord. Obviously.
Local council, Mr. PJ Seke is from outstation, I think.
I don't know, this Lingam Nochi, then Mr. Rintu Soike, if he's the leading council, Malaysia local council, Mr. Soike, Rintu
Raj
Soike.
Sekia is local, but
Yes,
Mr.
ma'am.
PJ Sekia is from Guwahati.
I don't know.
Yes, my lord.
He'll be appearing from, coming from Guwahati. So if a date is fixed, that may be
I
convenient
don't
for him
know.
also. But 12-12, don't take it on 12-12 because
Mhm.
12-12, many matters have already been fixed. Next available DB bench will be most probably if it is on Wednesday, then 12, maybe on 19th, 1911.
Okay, ma'am.
Not 19, Mal, can it be either 18 or 20, my lord? 19, I have some problem, 19, 20?
20 can be
20,
that case,
my lord. I'm not bad.
2011.
Online, ma'am.
We're listing it on 2011.
Lordship, I'd like to mention item number 14.
Yes.
I'm mentioning on behalf of T. Tagum, Standing Council for the Health Department. Parawise comment, we are yet to receive Parawise comment. Metro may be adjourned for 2 weeks.
We have
Have
to
taken
go
consent.
14. But Parawise comment has,
Yes, my lord, I on behalf of the petitioner, so last occasion they have taken time for filing of affidavit in oppositions.
you are yet to receive the Parawise comment.
Yes.
One more order was there on 16/5/2025, whereby since that the respondent number 15, whether you have issued notice on respondent number 15.
Yes, my lord, that has been done. Notice is issued to private respondent number 15, my lord.
They still awaited?
Still awaited, my lord. So we have taken a step on 20th May 2025, my lord,
Yes.
through our registry.
Yes, you have already taken on 15/5 notice also there.
Yes,
Heard Mr. N. Rama, the learned counsel for the petitioner, and also heard. You are appearing on behalf of Mr. Tagum.
Yes.
Your good name was Mr.
Arkoyu.
R. Koi, the learned counsel appearing on behalf of Mr. T. Tagum, the standing counsel health department. And it is submitted that the Parawise comment is yet to be received from the concerned department and hence need some more time to file their affidavit in opposition. Further, it is seen from the office note dated 3/11/2025 that the service report on respondent number 15 is still awaited. Let the service be awaited till next date of listing. After 2 weeks will be list
yes.
after 2 weeks, enabling the respondent to file their affidavit in opposition after obtaining the Parawise comments. List after 2 weeks. Okay, we are awaiting the service till next date of.
Yes. Much obliged.
And Lordship, I'd like to mention item number 16 with the consent from all the parties. Matter may be fixed on 15 December.
My lord, my appearance may kindly be recorded. I'm online. Item number 16. I am the petitioner, my lord. By filing the writ petition, we have challenged the rule. And during the pendency of the, my lord, writ petition, government framed the recruitment rules. Therefore, my lord, we have filed an additional affidavit and recruitment rule was brought on record. And they did not raise any objection. Now they want to.
It is already on record.
Yes, already on
Your
record.
this new
Yes,
rules.
yes.
Okay.
Yes.
Why you
So,
are
okay.
online, Mr. Prakash?
Hello. I'm not keeping well, my lord.
Okay.
I'm sorry, my lord. I'm sorry.
Okay. No, it's okay. Heard Mr. A.K. Purkast, the learned counsel for the petitioner through virtual mode. And also heard, you were saying that
No, on 15th, they have consented. On 15th, matter may be fixed.
Yes.
also heard the learned
15th of
counsel for
December.
the counsel for the appearing on behalf of Mr. Thakur, the standing counsel. It is the educational department
Yes,
or
this one.
of the
Yes,
educational
education.
department? And with the request made by learned counsel for both the parties, let the matter be listed on 15/11, 15/12.
15 December, 12, 15, 12.
Yes, it's 15 December. Okay, we are listing it on 15
Mild,
December.
mild, obliged.
Otherwise, here your pleadings are completed. Do you have any? Okay,
No, they didn't file, my lord. They didn't file.
they have already filed.
They,
No, through
they,
additional affidavit.
they are,
No,
additional appeal, they did not approach. They did not approach.
no. I'm asking that through additional affidavit, you have already brought on
Affidavit.
record.
In order to bring on records, the recruitment rules.
Uh,
Yes, yes. And now they are supposed to file the
Oh.
affidavit if they desire to file. And I
Okay.
was informed that they are awaiting Paraguay's comments.
Is it?
On, and Lordship, some more intelligence. 21 and 22, Lordship, the service upon respondent is still awaiting. Therefore, this matter may be
25.
21 and 22.
yes. This is a writ appeal filed by the
Hmm.
Department Education.
So have you taken steps or it's still
Yes,
awaiting?
I've taken a step and I've checked out the record. The service upon sole respondents, sole respondent is still awaiting in both the matters.
Sole respondent, na? It more or less same order ho.
In both,
Mane separately koriba, order will be same. Office note is also same on 3/11, do both the office notes are same. Part Mr. T. K. Soi, the learned counsel appearing on behalf of Mr. T. Tagum, the learned standing counsel for the education department. From the office note dated 3/11 for the sole respondent. Service may, let the service be awaited till next date of listing. List after 2 weeks will do. List the matters, both in alage bele list the matters after 2 weeks. As on a date to be fixed by the registry.
and last Lordship, item number 27. I have taken consent from the parties. This matter may also be listed after 2 weeks.
27, you are for the respondent, yes.
Yes, I'm the respondent.
Pleadings are already completed.
Yes, it's list.
Mr.
Listing for-
Deka, you are appearing here.
My lord, I am appearing for appellant. No objection.
No objection.
Yes.
Heard Mr. U Deka, the learned counsel for the appellant. And also heard Mr. Swenso appearing on behalf of Mr. T. Tagum, the learned standing counsel education department. With the consent of the other side, the learned counsel for the appellant paid for an adjournment. Prayer allowed. List the matter after 2 weeks or you want any date fixed?
2 weeks.
2 weeks, my lord.
After 2 weeks.
Yes.
List the matter accordingly after 2 weeks. As on a date to be fixed by the registry.
Your Lordship, I like to mention item number 4. I'm mentioning on the behalf of D. Mazumdar. Due to personal difficulties, he is unable to come today since he is out of station at Bogota.
3, 4,
Now,
and 5.
3, 4, and 5
5 are
are
connected.
all the connected matters.
Yes. It was filed almost a year back and it has not even been admitted yet.
Taka diboso, 3 at a time.
The difficulty is there's some cascading effects because of the pendency, though there is no stay order. There's some cascading effects. Because of the pendency, this is regarding seniority, my lord, retrospective promotion and all.
Okay.
There was already a direction from this honorable court in another petition, the seniority be fixed in the career of assistant engineer. Because of this pendency, that is not being done. And there are vacancies in the higher post of executive engineer. Because of the pendency, my lord, this also are not being considered.
Maybe
So do you want any fixed date? As he is saying that the matter is definitive from 24 onwards is only,
I have the instruction to, for seek, 2 weeks time.
Hmm?
2 weeks. 2 weeks.
in the, if it go by the order in order dated 29/1/2025,
Madam.
it was the submission from their side that the matter is urgent.
Yes.
That was reflected. So
That was at a point when they're urging for an interim order, so there was urgency. This honorable court has heard this matter on lots of occasions, including two honorable chief justices.
ah,
They were obviously honorable court was not convinced.
ah,
So now there is no longer any urgency.
interim is not,
Yes. No, it has not even been admitted, my lord.
not yet admitted. Three, 4, and 5 all are connected matters. You are Mr.
T Naga.
T. Raika. Your name is here?
No, madam.
Heard Mr. T. Raika, the learned counsel appearing on behalf of Mr. D. Mujumdar, the learned senior advocate for the appellant, and submitted that due to some personal inconvenience, Mr. Mujumdar is not in a position to appear before the court today. Mr. D. Panging, the learned counsel appearing for the you are
Private
the
respondent. Yes, in WA 28 and WA 35, madam.
appearing for the private respondents in WA 28, 24
Yes,
and WA 35 and /24 has submitted that matter is urgent, but due to adjournment prayed by the other side, the matter is yet not, the admission area is not yet completed. However, considering the submission made by learned counsel for the appellant, let all the matters, do you want any fixed date here? Because now see, Mozumdar has to come from Guwahati.
Yes.
it's a
After
bit
2 weeks,
difficult
he-
now because
difficult.
Honorable Justice Ete has passed one of the judgments. So I believe
Mr.
till
It says
2nd
that
of
will be
December,
here,
and roster is only till 2nd of December. That is the difficulty.
till 2nd of December.
That is what, yes. I-
Most probably till 2nd of December. If his roster is there on 2nd of December, then at best it can be if it is fixed on Wednesday, then 10/12 will be the next
Hmm.
date. 10/12. 10/12. It is a Wednesday, so you're fixing at the division bench on Wednesday, so 10/12 will be there.
Okay.
Okay, because we are fixing a fixed date because of your difficulty. Otherwise, he has to come from Guwahati, that's why.
Yes.
So 10/12 we are fixing. Hopefully go by the admission hearing on the next date of this.
Okay.
Obliged.
10/12.
Your Lordship, I'd like to mention one more or less. 29, item number 29.
20.
9. I'm mentioning on behalf of SV Dara, who is a legal counsel. Due to some personal difficulties, she was also unable to come.
It's at a jail appeal.
Yes.
How long your applicant, appellant is in custody since when?
Since I have no idea, madam.
You don't have any idea. The jail appeal, na?
And matter may be fixed in next week.
Mr. Darang will be there on the
Yeah.
next week.
Next week, yes.
Heard Mr. Semo, so and so appearing on behalf of Mr. S.V. Darang, the learned legal aid counsel for the appellant. And accordingly appeared for an adjournment due to personal inconvenience on the part of the legal aid counsel, Mr. Darang. Prayer allowed, let the matter be listed on next week, next 1 week, after 1 week, as on a date to be fixed by the registry. After 1 week, we are listing because they are from here only.
Yes.
So
Obliged.
My lord, I wish to mention item number 7. Not leading counsel G. Kato is on leave. So
item
I have
7 to divorce.
taken consent from other parties.
It is an order column, in fact.
Yes. My lord,
Whether service is completed.
service completed.
Awaited or completed. Completed.
Complete.
No, you were asked to take fresh steps on the respondent number 3 and 4.
My lord, they have
But it
acknowledged.
seems that you have not taken steps.
Respondent 3 and 4 have acknowledgement, my lord.
No, in spite of that, there was an order. If you go by the order, most probably on the last occasion,
Mm,
23/9/2025, there is an order.
Yes, my lord.
There may be some reason as to why the fresh steps is to be taken.
My lord, counter affidavit, so I have received from the respondent 3 and 4.
Counter affidavit.
Yes, my lord.
They have already filed.
Yes.
Yes, in one order I have seen, I think they have already filed the counter. Yes, Mr. Navam, you are appealing for
My lord, I am for respond number 1 and 2, my lord.
1 and 2.
Deputy
Do you know
Commissioner.
anything
has
about
seconded
the 3 and 4?
3 and 4, my lord, they are important party, my lord. Last time, if I correctly remember, or is Rentu Soika, Mr. Soika, he appeared, my lord.
Ah,
My lord, his name is there, my lord.
R. Sekya.
R. Soika, yes. Is the state
Then why this order was there for fresh steps? Do you have any idea? Because in the last occasion, that is on 23/9, there's an order to take fresh steps on the respondent number 3 and 4.
My lord, that must be a mistake
I
because
don't
last
know.
time, if I correctly remember, Mr. Rentu Soika, my lord, he appeared. So,
May I, Your Lordship? Your Lordship, my senior, Mr. Rintu Swiki, no more the standing counsel for the NIT department.
okay.
There is,
Oh.
Maybe because of that, my lord. Maybe because of that.
there is
Oh,
another
acha,
counsel in this matter
हाँ,
for the NIT.
अच्छा
Oh,
बोलना चाहिए था कांडो
then at this stage, Mr. One order and another order is there on 6/2/2025. The third para, it is dated at this stage, Sri G. Lolen, the learned council has submitted that he has been newly engaged as an NIT
Yes.
well
council. So I don't know when Mr. Lolen is here. No.
He's absent, my lord.
Huh?
He's absent, my lord.
Is there any way to inform Mr. Lolen? Then it's okay. Otherwise,
Your Lordship, my senior's name may be strike out from the first list.
okay. Okay. All this, your name is also not there. Oh, Arsakya is still there, na?
Yes.
Why the cause list, the SC land management is also there? Is there any?
well earlier my lord they had a standing council my lord now that has been discontinued now we government my lord we represent my lord
Oh, you're representing.
yes
Now only in that order, it is reflected that he has already appeared, Mr. Lolan has appeared
then when
and submitted, he has been already engaged as a new
engaged,
council.
correct my lord
But
and
thereafter,
why
I
subsequent that
don't know.
order has been reflected that notice has to be issued to respondent 3 and 4 my lord
To file the instructions also, he prayed time, granted 2 weeks time to obtain instructions in this regard. So that was the order. So no need, I think,
no need my
not
lord
necessary. Heard, Mr.
N. Karga, my lord.
and Kargo.
Karga.
The learned counsel for the petitioner, and also heard Mr. N.H. Nawam, the learned additional AG, appearing for the respondent number 1 and
1 and 2 1
It reveals from the office note as well as from the order of 23/9/2025 that fresh steps are to be taken against the respondent number 3 and 4. But it is from the submission made by learned counsel for the petitioner as well as Mr. Nabam, and from the order dated 6/2/2025 also, it reflects that Mr. G. Lolan has already been engaged as a newly engaged by NIT, and he also sought some more time for instructions from the concerned department. In view of this, this court is we are of the opinion that there is no need of taking any further steps for the respondent number 3 and 4. For the, in the same time, Mr. IBAM had submitted that Mr. R. Sakya, the earlier counsel for the NIT, has already is no more as a standing council NIT, and accordingly he prayed to strike out the name of Mr. R. Sakia from the cause list. A registry is accordingly directed to do the needful. Mr. Lolen, how will inform him now? That is the one issue.
My lord,
If
since
you have
he,
any,
my lord, since he has been engaged in a standing council, my lord, for the
Yes.
NIT, my lord, it is your responsibility. He should go through the cause list and appear, my when the matter is listed, my lord.
further, the registry is hereby directed to reflect the name of Mr. G. Lolen as a standing council NIT in the cause list.
My lord.
Mr. Lolen is also hereby asked to take the necessary instructions if as required for filing of the any counter affidavit.
My lord.
List the matter accordingly after 2 weeks.
Up to 2 weeks, my lord.
Your Lordship, I beg to mention item number 28. Lordship, I'm appearing for the respondents on behalf of Senior Advocate Mr. A. Apang. I kindly seek for an adjournment, Your Lordship, as he could not appear due to some personal difficulty.
28.
28.
Who is appearing here?
Senior Advocate Mr. A. Apang.
A. Apang. You are for the
Appellant,
government
my lord. Yes, my lord. State. My lord.
state.
State is the appellant here, my lord.
Yeah, state is the appellant here. This is in the hearing stage. Otherwise.
ma'am.
Yes, Your Lordship.
He is not available.
He is not available, Your Lordship, due to some personal difficulty, Your Lordship.
Your good name?
T. Wangmu, my lord.
T. Heard MST Wangu, the learned government advocate for the appellant, and also heard
K. Lawyer, Your Lordship.
K. Loyen, MSK Loyen, appearing on behalf of Mr. A. Apang, the learned senior advocate, and paid for an adjournment, stating that he is not available in the court today due to some personal difficulty. To which the government advocate also raised no objection. First off, raise the matter accordingly. After 2 weeks, will do.
Your Lordship, after 4 weeks.
After 4 weeks.
Yes, Your Lordship.
Raise the matter accordingly after 4 weeks for hearing as on a date to be fixed by the registry.
Obliged.
My ladyship, I beg to mention item number 20. My ladyship, the services is still awaited.
Service is still awaited.
Yes, my ladyship.
Itu diokson steps tulisan na silo.
He's in custody.
Yes.
Boxo ni. Boxo sa'yo. Additional PP is here. Yes, Ms. Lakshmi. Have you received
Item number 21.
your office seal is notice is received? So you have received the copy of the notice in item number
20.
20. You have received the copy of the notice because at present it has to go through your office.
Yes, Lordship, not yet, Lordship.
No, yes, it is.
Lordship, we Lordship in the PP office, Lordship.
PP office you have received.
Lordship, no, Lordship, in the here, Lordship, we don't have copy, Lordship.
We have, if you go by the office note dated 8/9/2025, it seems that you have received the copy of the notice. Your office.
Not Lordship, notice to be issued to the office of PP Lordship. It should be issued to our office,
Ah.
but we have not received back they have whether received or not received copy we have not
No,
received
I'm
yet,
not on
Lordship.
that. I'm just asking that if it is supposed received by your office, through your office, it has to
Yeah, we have already issued Lordship to our
Issued, no,
office. Yes,
to your
Lordship.
office.
Yes, Lordship.
So that's why I'm asking you to take instructions
Yes, Lordship.
regarding the service of notice
Yes, Lordship.
on the respond number 2,
Yes, Lordship.
because it is still awaited.
Yes, Lordship. We have already notice we have issued to our office. This is copied, Lordship. Office
Okay.
copy. Lordship.
Hana, it's okay. No, I'm just from the office note. I'm just saying that you have received the copy. It is allowed.
Not yet, Lordship. Yes, not yet.
No. Not the service notice. Notice you have received. It is
Lordship,
already
yes,
been
you
sent.
have already no, received.
Yes, okay.
We have delivered Lordship from our office.
Hard MS. You are
M. Jarang.
Hard MS M. Jarang, the learned counsel for the appellant. And also Hard MS L. Hagi, the learned additional PP appearing on behalf of state respondent. Office note dated 3/11/2025 reveals that TCR as well as the service report on the respond number 2 is still awaited. Of registry, they were directed to issue reminder to call for the TCR. In the same time, the additional PP, MS Al Hage, is hereby asked to take instructions in regards to service of notice on respond number 2. Let the matter be accordingly listed. After 2 weeks, will
Yes, yes, Lordship.
Yes.
Applied, Lordship.
Item number 1.
My lord. On last occasion, this court have directed the respondent number 3 to file a status report of solid waste management plant, which construction is going on in Chimpu.
Yes.
So till now, we haven't received any status report.
Yes. What
My
did you
lord,
say?
Your Lordship.
You are appealing for the IFT.
Yeah, my lord. I am saying, my lord. We will take some time for filing that, my lord. 2 weeks time
No,
may be
but
granted. my lord.
as per your information, do you have any things that the waste management regarding the waste management?
No, my lord, actually, I could not take instruction, my lord, because I was out of town for some personal difficulties, my lord. I'll make it immediately, my lord, urgently, my lord, make my communication to them, my lord. 2 weeks time may be granted, my lord.
And from your side, do you have filed your counter affidavit? Because that is the issue. If any proper steps has been taken regarding the management of waste management,
My lord,
then it will be easier for us.
my lord.
If you get the instruction, whether what is the plan, what is how they are doing, is there any steps taken for the waste management and all?
My lord.
That is okay. And what about the respond number 6 and 7? Oh no, sorry. Respond number 6 and 7. You are respond number 6 and 7. Who is respond number 6 and 7?
It's Panchayat, it's GA, government.
Panchayat.
Secretary and director.
Panchayat, Lordship, I am appearing for them
For 6 and 7, Panchayat. No?
also, yes. But then we are.
But then you want to submit any?
No, Lordship.
No.
Have taken instruction, they have not.
No. Okay. Your MS?
Somo.
Hard MS S. Tombo, the learned counsel for the petitioner applicant. And also Hard MS GAT, the learned additional senior government advocate, appearing for the respondent number 1. Yes, 1, 2,
And 5.
1, 2, 5. Now 6 and 7 also.
Yes, 6 and 7.
6 and 7. Stop.
4 and 5 have, we have already filed our.
Okay. And it is submitted that the counter affidavit has already been filed for the respond number 4 and 5. Further, on a full stop. Also heard. Yes, you are Mr.
T. Jamu, my lord.
T.
T. Jamu, my lord.
T. Jamu.
My lord.
Heard Mr. T. Jamu, the learned, the standing counsel for the IMC, submitted that he needs further 2 weeks time to take instructions from the authority concerns regarding the development of waste management system. He submitted that due to personal difficulty, he was out of station for 2 weeks, and for which he could not take the proper instructions. Prayer allowed. Let the matter be listed after 2 weeks will do.
Okay, my lord.
Let the matter be listed after 2 weeks, enabling the respondent to file their to obtain the instruction and to file their counter.
My lord.
Okay, after 2 weeks, it will be listed.
Major.
Item number 2.
May I please, Your Lordship?
Yes.
Your Lordship, I'm appearing on behalf of A. Kashyap here, Your Lordship.
Huh?
Appearing on behalf of A. Kashyap.
A. Kashyap.
Council.
He is
Your
not
Lordship,
present.
I've been directed that to inform this honorable court that the matter is in fructus, Your Lordship.
Fructus?
Yes. In view of this contempt petition, Your Lordship.
One contempt petition was also there. No?
Yes.
It was told that there's no willful contempt, and at that effort, there was an assertion from the respondent number 2 that all efforts shall be made to upgrade or repair the 31-kilometer stretch highway.
Yes, Your Lordship.
That contempt was actually against the order of the single judge in WPC 198 oblique. That was the contempt or no?
No,
against the PIL.
PIL, Your Lordship.
Other PI was
Yes,
there.
Your Lordship.
Oh. Oh, acha. Contempt petition. The respondent has sought for extension of time to comply with the order. That is PIL 101/2023.
Yes.
The reflecting is consulted on the PN to the order only the 31-kilometer stretch away to Koilo. It's no more exit.
नाम तो खाली एक बोलेगा. You're on record.
No, Your Lordship, I'm appearing on behalf of Akash.
You are not on record, no?
No.
You are Mr.
E. Menjo.
E.
Menjo.
Menjo.
Yes, Your Lordship.
Heard Mr. E. Menjo. The learned counsel appearing for Mr. A. Kashyap.
Yes, Your Lordship.
A. Kashyap for the appellant, and also heard Mr. G. Tara, the learned standing counsel for the respondent number 1, 4, 5, and 6.
Yes.
And MS Ete, Miss Ete, you are appearing for
2, 3,
2, 3, and 7. And also heard MS E. Ete, the learned senior government advocate for the additional senior government advocate for the respondent number 2, 3, and 7. Yes. The matter was stayed for admission hearing, but it is submitted by Mr. Manju, the counsel appearing on behalf of Mr. Kashyap, that in view of the order passed in BI contempt,
458 of 20. Contempt. 458.
contempt case number 458 of 2020, the matter has already become infructuous, and hence they doesn't want to proceed with the case further. Full stop. Next para. It is seen that the present appeal was the present appeal the appellant have assailed the judgment and order dated 11/8/2023 passed by learned single judge in WPC 198 AP of 2020. But during the pendency of this case, one connected contempt was filed against the order of the court in PIL 101 of 2023. Full stop. It is seen from the order, the copy which it is seen from the order passed in PIL, contempt case number 458 of 2020, dated
2410.
24/10/2025, that the contempt was accordingly disposed of with an observation that there was no willful contempt of the court's order, and especially in view of the assertion of the respondent number 2 that all efforts shall be made to upgrade or repair the 31 kilometers stretch between SEDDE Sede Pakro PAKRO, which was left out in the new alignment as far as it is possible. So considering the order passed in the contempt case as well as the submission made by learned counsel for the appellant, we are of the opinion that the present writ petition has already become infructuous and accordingly disposed of, rendering infructuous. Okay. Nice.
Item number 6.
Please, Lordship.
Yes.
Lordship, my case before Honorable Single Bench was that the government has approved a land measuring 400 square meters for allotment in my favor, my club, Lordship. Before approval, Lordship, there was a land management committee, district land management advisory board, was supposed to done the survey and the feasibility report of the land proposed to be allotment. After completing entire formalities, the government has recommended for approval before the competent authority for issuance of land allotment orders. Approval that is done. Now, it was supposed to be issued land allotment passbook by the deputy commissioner. Only for the purpose of issuance of the land allotment passbook only, Lordship. But it was not issued by the deputy commissioner.
No, land allotment order was?
Order was issued by the government.
Government. Okay.
Government. Approval, everything was done. Only the direction was issued to the deputy commissioner for issuance of land allotment passbook only. But it was not issued by the deputy commissioner, and deputy commissioner, without any reason, withheld for issuance of passbook. In the meantime, Lordship, what happened? Out of that 4,000 square meters, 2,500 square meters of land was allotted to BJP from my approved land. It was before cancellation, Lordship. It was allotted to the BJP, and then another, Lordship, 600 square meters was allotted to Karate Association. Karate Association. Now, after came to know about that allotment, illegal impugn subsequent allotment in favor of the BJP and Karate Association, the petitioner made an inquiry. Appellant made an inquiry before the authority as to why the same my land, which was approved for allotment in my favor, has been allotted, subsequently allotted to the BJP. Then only, Lordship, the clarification, cancellation order, the petitioner came across at phase number 110 of my appeal, Lordship. May I take you to the 110? Annex 13, Lordship. 110.
Yes.
Now, this is the clarification. This is only the cancellation, but in fact, this is not a formal cancellation order. But by this clarification only, the petitioner came to know that the land has, my allotment was cancelled. But without prior notice, nothing so-called notice, nothing was given, Lordship. May I read, Lordship? This clarification was issued to the Deputy Commissioner on 3rd April, Lordship, 2018. My approval was made on 28/6/2012, and this clarification was issued on 3rd April. Clarification on allotment of government land for BJP State Head Office regarding. Sir, regarding government approval for allotment of the government land in favor of Bharatiya Janata Party at this sector Itanagar near Tennis Court, IGFR for construction of BJP State Head Office Itanagar, it is clarified that how the land was allotted to the BJP for construction of their head office. That has been clarified here, Lordship. 1. Out of 63.30 acres of government allotted land to Forest Department, an area measuring 957 square meters was already approved for allotment to the Arunachal Pradesh Club. That is another different allotee, Lordship. Arunachal Pradesh Club and 4,000 square meter for Itanagar Club. Within that 63.30 acres of government land, now, Lordship, 400 square meters was 957 square meter was approved for allotment to Arunachal Pradesh Press Club and 4,000 square meter for Itanagar Club, my club, Lordship. 2. The land for Arunachal Press Club is no more required as it has already been resolved for an alternative lot. Means the land which was approved for Arunachal Press Club was no more required because they have been given alternative lot, Lordship. Eastern has been reserved for alternate floor. Therefore, 957 square meters allotted to Arunachal Press Club is then cancelled. His allotment was cancelled because he has been provided alternate float. Now, similarly, the land allotted to Itanagar Club, measuring 400 square meter, approved in principle, also is then cancelled. Now, the land approved for Arunachal Pradesh Press Club was cancelled because they have been given alternate float. But my 4,000 square meter, which was approved in principle, has been cancelled. But for what reason, nothing has been reflected. Now, third, out of 4,957 square meters of land, as shown in Figure 2 above, an area of 2,500 square meter is carved out and allotted to BJP State Head Office, since the allotment is being made from out of 4,957 square meter cancelled land allotments. Thereby, the NOC from Forest Department is not required. Now, Lordship, my allotment, my approval that for out of 4,000 square meter that has been cancelled without assigning any reason, but immediately and subsequently, the same land has been allotted to the BJP for construction of their head office. Now, for this reason, Lordship, I have filed writ petition challenging this impugn order. Now, during writ proceeding, the Deputy Commissioner, they have filed their affidavit saying that, Lordship, the land allotment in respect of the petitioners has been cancelled because there is a government notification that entire that area falls within the wildlife sanctuary area. Now they are taking different ground, Lordship, in writ proceeding. There is nothing ground saying that my allotment was cancelled in this infine order, Lordship. That my allotment was cancelled because the land falls within the notified area of wildlife sanctuary. But it was only they came up with in affidavit before the writ proceeding, Lordship. Accordingly, Lordship, the writ petition was disposed of, directing that the land allotment cancellation, this infine cancellation was not interfered by the honorable single bench, saying that cancellation was made because there is a notification the land falls within the wildlife sanctuary area. It was my ground, Lordship. Now, Lordship, and during that writ proceeding, Lordship, the Deputy Commissioner filed an affidavit regarding the status in respect of the land subsequently allotted to the BJP and the Karate Association. They have said that entire land allotment has been cancelled. But as of now, Lordship, no cancellation order has been issued in respect of that both private respondents, BJP and Karate Association. Now, still the land are in possession, physical possession of the Karate Association, Lordship. Now they have committed forgery before the single bench also, Lordship. For that, we have already filed a contempt proceeding. Different, of course, that is different proceeding which is pending before the learned single bench. Now, Lordship, as of today, may I humbly pray that Lordship, let the
So as per their affidavit in the writ petition,
yes, Lordship.
the allotment for the BJP and the Karate Association also been cancelled.
Yes, they have stated. But the practically, Lordship, that is not done till today.
So whether
The land
there
is in
whether
physical.
there is any permanent construction is there?
Yes, Lordship. There is still construction is going on, Lordship. That is why, Lordship, today I humbly pray that Lordship, a specific direction may be issued to the Deputy Commissioner to submit the actual status report of that particular plot of land which was allotted to both respondent, BJP and the Karate Association. And in the meantime, if it is already cancelled, then take the possession and control of that particular plot of land, Lordship. Because otherwise, during pendency, Lordship, they will complete their construction, illegal construction. Because the authority has submitted affidavit before this honorable court saying that the allotment has been cancelled, but factually that is not done. Still construction is going on, Lordship.
Lordship, already is submitted by my learned friend, Lordship. As per my instruction, they said they have initiated for cancellation of the allotment.
That is the problem, Lordship.
They have initiated. They have not said that they have cancelled, but they have initiated the process. That was my.
That means it is still it's not yet cancelled.
So, Lordship,
Process is initiated.
process has been initiated. That was my instruction, Lordship. So, after hearing the submission of my learned friend, Lordship can direct. I have no objection to that.
Strict direction may be
For
issued,
the-
Lordship.
Single judge order you are assailing on what grounds in this appeal?
Yes, I'm excelling on the ground that, Lordship, when there is a judgment also, Lordship, in Mohinder Singh Gill, when the cancellation was done, my land allotment was cancelled not on the ground that the land was fall within the notified area, Lordship. It was cancelled, no ground was given, but it was, to my understanding, my land allotment was cancelled only to give allotment to the BJP and Karate Association. As I have shown, Lordship, the infine order. And allotment, in fact, allotment to the subsequent allotment to the BJP and Karate Association was done without any issuing any cancellation order. But on my query, this 110, page number 110, infine clarification order, it was only issued. But here also, Lordship, it was saying that my allotment was cancelled and carving out 2,600 square meter and it was allotted to BJP, Lordship. Now, during writ proceeding only, they came up with new ground by the respondent lordship, saying that there is a government notification that this land falls within the wildlife sanctuary area. And I have filed reply to that affidavit also, lordship. If that is the case, lordship, then entire capital area will fall within the notified area, lordship. But my reply was not taken into consideration, lordship.
By the
Yes, by the honorable single bench.
যদি ইনিশিয়েশন হয়েছে already heard Mr. K. Lolen, the learned counsel for the appellant, and also heard MSG 80, the learned additional senior government advocate for the state respondent. It is submitted by Mr. Lolen that they have assailed the
judgment.
Yes.
4/12/2020.
SLD
4/12.
judgment order dated 4/12/2024 passed in WPC 229/2023. It is submitted by him that initially there was an order of allotment. Allotment order was approved by the government, and it was directed by NGC was directed to issue notice accordingly for the allotment order. But without his knowledge, the allotment order was cancelled, which was issued in favor of the present petitioners, and out of his 4,000 square meter order land, a portion of land was allotted in the name of one karate association and for construction of the BJP head office.
6 and 7.
But BJP head office, but during the pendency of the writ petition before the learned single judge, it was brought by it was stated by the state authorities that the land which was allotted in the favor of the petitioners falls under the wildlife sanctuary area, and for that reason only that or the allotment order was cancelled. And it is also the plea also taken that the land which was being allotted to the BJP office as well as the karate association is also submitted that the process has already been initiated for cancellation of the land allotment for the BJP head office as well as the karate association. But as per the instructions from his clients, it is seen that those lands are still under the position of the karate association as well as the BJP head office, and the constructions are
So illegal
still-
construction.
Illegal constructions are still going on. Mr. Lolen accordingly submitted that the state authorities may be directed to take instructions in regards to the process of initiation of the cancellation, process of the cancellation of the allotment orders. Post of MS Ete, the learned government advocate, submitted in this regard that she need some time to take instructions in regards to the initiation of process of cancellation of allotment order in favor of the BJP office as well as the karate association. In view of this, the state authorities state respondent is hereby directed to take instructions, additional government advocate is hereby directed to take proper instructions from the authority concerned regarding the process of initiation of the cancellation of allotment order as stated in the during dependency of the writ petition. List the matter accordingly. After how many weeks you need?
After a week, Lords.
After a week. List the matter accordingly after a week as on a date to be fixed by the registry. You just take instruction because if it is cancelled for, if it is falls under the suppose the wildlife area, then obviously the other two there should be cancellation.
And
So
Lordship,
there
may
will be-
humbly pray that one more line may be added, directing the deputy commissioner to get the current status of that disputed land.
Further, the deputy commissioner is also hereby directed to furnish the current status of the allotted land to the said BJP office as well as the Karate Association.
Deeply obliged.
Item number 8.
Yeah, my lords. I have filed, rejoined to the affidavit, additional affidavit filed by the respondent number 12. Here,
Under
respondent number 12, I have filed.
for respondent number 12,
Yes. Additional
rejoinder
affidavit,
you have filed.
yes. So after filing of this PIL, it's been 2 years. They have extended 3 times for the completion of the road construction. And the submission they have made here is misleading the code because if my lords may come to page number 184 of my rejoinder. It's annexure 3.
184.
Yes.
Rejoinder very close.
184. One eight four, ma'am.
Rejoinder affidavit বেলেগ কে আছে নেকি চাম?
No.
Rejoinder এখানে উলিয়ে দিও। সেটুটা।
Oh.
Yes, 184.
It is the status report filed by respondent number 12 on 30th June 24. Till the 30th June 24, they have submitted that by the end of September 2024, if the weather will be favorable, they will complete the project by 31st of March 2025.
So now what is the position?
Till now, by the February, they have said that they have completed 90% of the work. But till now, they haven't filed any status report saying that the project is completed. And it's been 2 years that the matter is pending, and it is 17 years that the project is pending. And they are saying that the NSC had withdrawn their this sanction. And but if your Lordship may come to page number 199 of my rejoinder, it is not very visible. State have also sanctioned 19 crore. It is almost 20 crore. It's 19 crore, 92 lakhs. So they are making excuses that there is no fund. And every status report, they have stated that if fund is available, they will complete. But they have nowhere mentioned that how much fund they have still. And they have never submitted utilization certificate to the department. So, and their window period of working is from October till April last. And most of the time, October is festival season and it is just go. And the most favorable season of working is November. And after that, in December and January, it will be festival season. So they will give the excuse of the labor is not there and all these things. So as per the instruction of petitioners, now they are saying that there is no work is going on from the February of this year, 2025. So we are very skeptical that whether this project is ever going to complete or not. And the importance of this project is that this is a strategic project. Most of the time when states say that it is a strategic project, they force the people of that place to comply with them. But when the people of the place comply, they never complete. And the for project, the area has given is free, of course, is given by the people of that area. So it's been 17 years that the people of that place is facing the issue of the non-availability of road. So
It is basically what
road construction.
road construction.
Yes, it's 81 kilometer. And
1 kilometer.
yes, it's almost 200 crore is granted by the NSC and the state combined.
Yes, do you have any instructions in that regard?
No, my lord, but my lord, on the last occasion, my lord, we have submitted one status report, my lord. Dated
Status
19,
report.
yeah, my lord, 31/1/2025, my lord. It was
Election 31/1.
Yes.
Status report. Nahan itu nahan 24.
It is in page number 182 of my rejoinder. 182.
Their status report.
Yes.
And according to this status report, my lord, work was to be completed by 31st March of 2025, my lord. So, my lord, 31st March, my lord, of 2025, my lord. Now, my lord,
already gone.
yes, my lord. So, my lord, maybe my lord, work has been completed, my lord. I have no idea, my lord, regarding that, but we have created my
As per instructions of our client or the petitioners, since month of February 2025, there's
Yes,
no
madam.
construction work is going on.
I have no idea regarding that, my lord, but it was to be supposed to be completed by 31st March, my lord. So, my lord, may I present my lord, this matter maybe?
So as per your status report,
Yes, my
which is they have annexed in the page number
Yes, madam.
182.
Yes.
As per you, what was the progress of the code? Was 80%, 90%? What was the percentage? Can you tell us?
Dear my lord, in the status report, it's given, my lord, like target of work and achievement, my lord. It's given. my- Target of work was 36 kilometer, achievement was 20 kilometer, my lord. First column, my lord.
Balance target is 16.
Yes, WBM, my
But
lord.
whether it is a 36 kilometers or 81 kilometers?
36, my lord, WBM, and
Total stretch is 81 kilometer.
but
total
my lord,
stretch is
yeah,
The pending
36
is
kilo-
36.
Yes, but 36 kilometers WBM, my lord, where only that stone and sand was to be placed, my lord. And this black topping is 45 kilometer, my lord. So, my lord, black topping, my lord, after WBM, my lord, black topping is done, my lord. So, my lord,
But it seems that if you go by the black topping,
Yes, my
then
lord.
45 kilometers was there and the
But
6
six-
kilometers
yes, my lord,
every
but-
achievement is there.
Yes,
isn't
my lord.
it? And 39 is still.
Still balance.
Your status report is of dated 31
31/1/25.
2025.
Yes, my lord.
So can you
That's why, my
expect that within
2
months or say
Black
within 3
topping,
months?
my lord, it's possible, my lord. According to my instruction, my lord, but black topping is possible, my lord, because after road cutting, my lord, it's easy, my lord. To do this after WBM, my lord, it's easy, my lord, to black topping, my lord, for black topping. So, my lord, may I pray that, my lord, because here, my lord, we have written that 31st March will complete, my lord. So after 31st March, my lord, I have to get instruction, my lord, whether it's complete or not. Matter will be fixed for hearing, my lord. In the meantime, I will bring the records, my lord.
You are appealing for?
I'm for respondent number 1, 2, and 3.
Who are
Union
they?
of India. On behalf of Mr.
Union of India.
Yes, madam. As per instruction, respondent number 1, 2, and 3. Perform.
Perform.
Yes.
করাই দিতেন না বলতে কথা ছিল ফার্স্ট টাকা নাই আমি মনে আছে
What is your reply to her submission that it should be posted for hearing in the meantime, the records?
Yes,
Can that be-
status report may be submitted.
Can that be done? Take it to hearing?
Pre-completion report if it's completed.
It's completed, but I have annex here, few annexures as per the the work they have done as per last occasion which we have when the work they have done is substandard. So that is also substandard work they have done, which is they have done. It's just 2 or 3 kilometers which they have done. So there are some news clippings also we have attached here. So it is also one issue that it should be the quality work. So we are skeptical. That's why we have already made prayer here that there should be one committee so they can look after. And
what about that regarding your prayer for construction of a committee or constitution of a committee? Is there any?
there is no committee committed till now formed. So
Okay, let us see the report after
Yes,
first.
ma'am.
maybe given fixed date in next week, Your Lordship. So because their working window periods are very short, so
Very
we are
short,
yes,
yes,
very short.
obviously.
October from this till April they work, and from next month from December they won't work because it's festival season. So we are very skeptical that after they work or not. So it's within like November. So maybe given next week date, fixed date. Maybe.
Your MS S. Somo?
Yes.
Heard MS S. Somo, the Learned Counsel for the petitioners, and also heard MS
T. Wangmo, madam.
T. Wangmo, the Learned Additional
No, my government advocate for
Government Advocate.
Yes, ma'am. 4 to 12, my lord.
Government Advocate appearing on behalf of 4 to 12. And also heard Mr. Ansora appearing on behalf of Mr. M. Kato for the respondent number 1, 2, and 3. It is submitted by Mr. Somo that, sorry, MS Somo that they have already filed their affidavit in reply, rejoinder affidavit, wherein rejoinder affidavit and as per the instructions as well as 184, no? No, rejoinder affidavit, but it is submitted that as per the status report of submitted by the state respondent, they have completed 90% of the work and it has to be completed within 31/3/2025 if weather is favorable. But as per her instructions, the construction, there is no 90% of the construction. No, sorry, there is no. Yeah, there are some constructions work, but
it's substandard.
There's some constructions were going on in the said road
Till February they have worked.
till February 2025, but the works are of substandard and substandard. Full stop. Further, is submitted that in 199 we have said that 19 crores has been sanctioned, na? Subsequently.
That is from state because this project was sanctioned by NSC. So this sanction was given by state in addition to 200 crores. Yes.
But it is submitted that it was the sanction amount for the construction was 200 crores, which was sanctioned by the NSC, and in addition to that, the state has already sanctioned 19 crores for the completion of the said work. But till date, there is no utilization certificate has been submitted by the state authorities. And as per the instructions of the petitioners, no work is going on from February 2025. Post. Next para, in that context, Mr. M.S. Wangu, the learned government advocate, submitted that as per the status report submitted on 19/12/2024, the balance work is to be was to be completed within 31st of March 2025. And as per the status report, already around 80%, it will be considered as a how many percentage? 70, 80, I cannot say now.
Till now, they haven't found any.
This percentage, that the a considerable, submitted that the out of targeted works for WMB of 36 kilometer, they have already achieved 20 kilometers of this said project, and only 16.0 kilometers remain the balance target. And in regards to the blacktopping, the target was of 45 kilometers, and they have achieved the work has already been achieved is 6 kilometers, and remaining 39 kilometers as a balance target. She submitted that she wants to, she will take the proper instructions from the authority concerned regarding the construction of the balance target, and which is to be balance target. So accordingly, she needs some more time for the same. MS Somo further submitted that though there are some constructions work, but the work standard is but the substandard work is but the work standard is below the submitted that there are though some works has been done, it was substandard, and for which it was urged to constitute a committee to supervise the work, but that has also not been done by the state authorities. Post op. In view of this, the state respondent is hereby allowed 1 week time will do. 1 week time to file to submit the status of the road, status of the project work, and status of the present status of the work, targeted, present status of the work, progress oblique status of the work completed so far by the authorities. List matter accordingly.
Fixed date may be given. Fixed date next week, 12 or 13.
My lord, 18, my lord.
18.
Because this is Siang Daja, my lord, it's far, my lord. 18, my lord.
18.
Because 18, it will be again
11.
in the, yes, it will be last of the month again.
Last of the month means?
Like they have very short period of working period of window. That's I already informed this code. So from December it won't work. So if they will give in,
If my lord, work is completed, then my lord, there's no.
just they have to file a status report. It won't take that much time. It will be just 3-4 pages. So next week will be better. Fixed date maybe.
Oh, it's 17, my lord.
Next week you will be able to?
No, my lord, 17, my lord.
17.
1 week time.
1 week time. Okay, then 17, 11. And matter may be fixed for hearing?
Yes, my lord.
Okay. And matter may be accordingly fixed for hearing as on it fixed for hearing. Not like 17, 11 for hearing list. Hearing for. Milai dibo eto apni.
Item number 9 and 10.
May I, Your Lordship? Lordship, as per the office note dated 3/11/2025, service report upon.
Yes.
It's not dated 3/11.
3/11, Lordship. Service report upon respondent number 4 is still awaited in item number 9, Your Lordship.
Yes, 9 and 10, what you have submitted?
As per the office note dated 3/11/2025, service report upon respondent number 4 is still awaited, Your Lordship, in item number 9.
Four is awaited.
Or is still awaited?
Yes, Your Lordship.
And in item number
In item number 10, respondent number 5 and 6, Your Lordship,
5
still
and 6
awaited.
are still awaited.
Lordship.
So you are appealing for
I'm for respondent number 3.
respondent number
3.
3 in both the items or
Yes.
in both the items? Same order নিচিনা হ'ব. So it is the appeals are by the state.
Yes, by the commission, APPSC, Your Lordship.
Hard MS and Anju, they learned. You are standing counsel here or how, in what strength you are appealing?
On additional standing counsel for
Additional
APPSC.
Standing counsel APPSC.
Lordship.
Additional standing counsel APPSC. And also heard URMS, Mr.
L Taj.
L.
Taj.
Laj.
Taj.
Taj. L Taj. You're appearing on behalf of someone?
Yes, Your Honor.
Appearing on behalf of Mr.
S.K.
SK Deuri.
Yes.
SK Deuri for the respondent number 3. It is submitted by MS Anju that in the WA 32/2023, the service is still awaited for the respondent number 4. And in WA 33/2023, the service is still awaited for the respondent number 5 and 6. You have already taken steps.
Yes, Your Lordship.
So do you want to await the service till
Await
next date of
service,
listing?
yes.
Let the services be awaited till next date of listing. List both the matters accordingly on after 2 weeks.
After 2 weeks.
Yes, after 2 weeks.
Obliged.
Item number 11.
Apa ini? No,
No affidavit for respondent number 10.
My lord, I was supposed to file the status report, my lord. So may I humbly pray, my lord, at least 1 week time, my lord. Next week, my lord, by Tuesday, Wednesday, I'll file it, my lord.
May I please? You will also kindly peruse order dated 25/09/2025.
You know, that's what I'm perusing.
You will also, in terms of that order, you will also, this matter may be dismissed on the ground of non-prosecution. Your Lordship, since the petitioner is not appearing since last 2 occasions and this is the 3rd time. Your Lordship.
Dismissed for?
On the ground of non-prosecution.
No.
He's not appearing since last 3 occasions. Your Lordship. And as per the order dated 25/09, it is noted that the petitioner is not represented when the matter is taken up for 2 consecutive dates. Therefore, on the next date, if default continues, an appropriate order shall be passed.
Today also non-appears?
Yes, he is not appearing.
Only that I don't know. Petitioner.
So who are appearing for the respondent number 5, 6, 9 and 12?
I'm for the respondent number 12.
Yeah, for the respondent number 12. So you have also not filed any your affidavit you file? You want to file or you have not? Because the order speaks that respond, but also by the respondent number 5, 6, 9 and 12. They have also not filed the affidavit.
No.
6, 9, my lord.
Huh? You have already filed.
15, 9, 24, my lord.
You are for the respondent number 6?
1, 2, 4, 5, 6, and
Seven,
1,
seven,
2,
eight, nine.
4, 5, 6,
6, 7, 8, 9.
6, 7, 8, 9. So for them, you have already filed. So 12 you are representing. 12 you have a file, your affidavit.
We've already filed, respondent number 13 and this, 11, 17, 10, they have already received. It's already, they have received, signed in.
No, you are for the 12.
12.
Whether 12 has filed already.
Yes, we have already served a copy.
Serve the copy is otherwise you have. No, you are representing the respondent number 12.
Respondent number 12.
That's what I'm asking,
Yes.
whether you have filed.
Affidavit, that we don't, still did not.
You want to file or you are not going to file?
No, we'll file.
So you have not filed?
Yes.
But then, yes, it was specifically directed.
Yes, my lord. I'm extremely sorry for that, my lord. Just may I humbly pray, my lord, only 1 week, my lord. I'll file it by Tuesday or Wednesday, my lord. The coming week, my lord.
10.
Yes, my lord.
So what are you saying that non-prosecution means what?
Since he is not appearing in this matter here.
Yeah, petitioner is not appearing.
This is the third time here. The petitioner is not appearing.
Petitioner counsel, you mean?
Yes.
Yes, sir.
Not appearing.
Yes, sir.
You all are for the respondent.
Yes, Your Lordship. We are
Oh, I thought that you were for the petitioner.
No, Your
That's why I'm just confusing. They have not appeared. No, none appears on call
Lord.
last occasion also.
Yes,
It
Lord.
says.
Last one.
Mr. K. Mena was appearing, na? And for 1 decade, Das was there.
My lord.
So then,
Same may be dismissed, Your Lord. As it is already noted in the earlier order also.
Appropriate orders, not this, maybe which includes dismissing or not.
Yes, Your Lord.
To
action di diok ni na hosi.
if all appropriate. Yeah.
So what is the status of the case or?
My lord, we have already registered an inquiry report, my lord. But I filed my PDP in opposition, my lord. But there was a direction because it
It is already, the case has already been registered.
no case has not been registered, my lord. But there is an inquiry, my lord, as per section 17A, my lord.
Still under inquiry.
Yes, my lord. So, despite the fact that, my lord, I've already filed my affidavit, my lord, in opposition, my lord. However, the court has directed me to file the status report, my lord.
Status report.
Yes.
In a way of affidavit.
Yes, ma'am.
In addition to the affidavit.
Yes, ma'am.
Now let us see, suppose if you file the status report on the next date,
My lord.
then the court will also come to know that regarding the status of the case.
My lord.
What is the stage of the inquiry, whether this has been registered or is going to be registered, or what is the inquiry stage?
My lord.
So in that case, if it, even if suppose the purpose of filing the PIL will also, I think it will be served also. In that case, it will
The
be.
prayer, if, my lord, comes to the prayer also, my lord. The prayer only ask for direction.
Direction
or,
only.
yeah, only direction to register the case in the vigilance cell, my lord. Or Central Bureau of
If you
Investigation.
file the status, then
Probably,
it will be more convenient for the court also
my lord.
to dispose of the entire PIL.
My
If they appear, if it doesn't also. Most probably they have the instructions also that the inquiries is going on, and that may be the reason they have not appeared in the PIL. Oh, but
They should actually. It should appear.
okay, then one more chance will be given. In the next date, if the status report comes before the court, then it will be.
Next week, my lord. Next week.
Next week can be, yes. None appears on call for the petitioner. Heard MS E. Wangu, the learned additional comment advocate, senior government advocate, appearing for the state respondents number 1, 2, 4, 5, 6, 7, and 9. And Mr. Tarak, you are also appearing, na? Pending counsel PWD for the respondent number 3 and 8. Yes, and Mr. O. Pada, the Learned Standing Council oblique comma vigilance for the respondent number 10. And Mr. I. Bum, the Learned Council for this 11 and 17.
Yeah, 11.
11. And you are MS?
D. Rilung.
D.
Rilung,
Appearing on for the respondent number 12. It is submitted by Mr. Pada that he was supposed to take instructions and to file the affidavit in that context regarding the status of the case. But due to some personal inconvenience, the instruction could not be collected by him, and accordingly he submitted that 1 week time may be required to file the present status of the case as well as the affidavit. Prayer allowed. Full stop further, it is seen that on the last 3 occasions consecutively, on the last 3 consecutive days, the petitioners remain absent on call. However, after filing of the present status report of the case, the matter may be disposed of accordingly. In view of this, they let the matter be listed after 1 week.
My lord, may I fix a date, my lord?
Fix a date. Okay.
Can it be on 12 or 13, my lord? Any date?
Maybe on 12 because it is a 12/11/2025. Fix koi. Okay, we are fixing it on 12/11.
My lord. Obliged.
We'll just file the status and then it may be disposed of.
My lord.
Item number 12.
Ma'am, my lords. My lords, here to respond number 5, 6, and 7 services awaited, so we may be given time to serve.
Services awaited for 5, 6, and 7.
Yes, it's private respondent.
But you have taken already steps. You have taken.
It's taken, but it's not served. So
Services awaited.
Card is not come.
Heard MS S. Somo, the Learned Counsel for the petitioners. And also heard Mr. N.H. Nabam, the Learned Additional AG, appearing on behalf of, you are appearing for?
My lord, I am for respond number 3, 4, 2, 3, and 4, my lord.
2, 3, and 4.
Yes.
2, 3, and 4. You also appearing for respondent number 1, and also heard Mr. G. Tara, the Learned Standing Council appearing, Learned Standing Council RWD appears for the respondent number 1. From the office note dated 3/11/2025, it is seen that the service is still awaited for the respondent number 5, 6, and 7. Let the service be awaited till next date of listing. After 2 weeks, we'll do list accordingly after 2 weeks, as on a date to be fixed by the registry.
Much.
Item number 13.
But it seems that the counsel for the petitioner is absent today, madam. However, madam, the investigation is going on, madam. Case has already been registered. The basic period of the petitioner is for, madam, the registration of the case by the CBI and to be investigated by the CBI, madam. So, madam, CBI.
As per your instruction, the case has already been registered. But it is under the investigation of under CBI or?
No, madam. Arunachal Pradesh Police, madam.
Police, Arunachal Police.
The case has been already registered. Investigation is also going on, madam. CBI and the central government is nothing to do with all this case, madam. So therefore, it is inter-state, madam, the dispute, not inter-state. Within the state, madam, there was some place, public move in the town, madam. So that has to be, madam, the basic barrier is, of the petitioner is, it has to be investigated by the CBI, madam. But the case has already been registered by the state police, madam. In our affidavit, madam, we filed the affidavit before the Honorable Supreme Court of India, which has been transferred back, madam. We relied upon the, madam, the statement of the affidavit filed by the, madam, the CBI. Lordship will find in our.
Yes, one order of the Supreme Court is also here, no?
Yes, ma'am. Para, madam, specifically, madam, para 7, 8.
Of your affidavit?
Yes, ma'am.
In page
And
number? Can you
page
tell
number,
us?
madam, the page number 3 and 4, madam.
A rule action, what is that?
Affidavit filed by the CBI, my lord.
It's originally filed in the Supreme Court.
My lord.
Supreme Court,
Yes,
and it came here.
transferred. It starts from the page number.
Page number?
2. I say that the present writ petition has mentioned 4 FIRs lodged at Tawang Police Station.
Yes. Just
Tawang,
see it down.
yes. Tawang PS case number 12 of 2016 under section so and so.
Tawang PS case number?
2012 of 2016.
No.
Tawang
2000?
PS case number 12 oblique 2016.
2016.
Madam. And section is also given, madam.
Acha.
153A oblique 295A oblique 506 IPC, madam. And second is Tawang PS case number, madam. Altogether, 4 cases has been registered, madam. Tawang PS case number 13 of 2016, 14 and 15, madam.
Mr. Kato, have you filed your affidavit?
Madam, we are relying upon the affidavit filed before the Honorable Supreme Court, madam.
Till that, as
Yes,
per the office note, it is not available with the court. I don't know if you file, we saw the as per the
Entire records
office note of 3/11/2025 also, affidavit is not yet filed by the state.
State, madam, the state, our affidavit has already been filed, that is.
State has not been
State
filed.
has not been filed.
Your affidavit has been
My-
filed.
my-
It can court file पूछे बोले.
The same
State
affidavit
economy, state
which,
economy.
which was filed there.
Yes,
Your affidavit.
that has been transferred
Transferred.
Absolutely.
by the order dated, madam, of the Honorable Supreme Court.
Anyway, Mr. Kato, now they are absent. The state is yet to file the affidavit, I think. But as per you, the case, 4 numbers of cases has already been registered and the investigation is still going on. But not under the CBI, but under the Arunachal State Police.
Correct.
The last question. Anyway, however,
At the most, madam, the status of the 4 cases can be obtained, madam, by the state.
Lordship,
Investigation might have been completed.
we'll need 3 weeks time, Lordship. We have received our instruction. Your worship.
and you have
Instructions
not
here.
filed your affidavit also?
Yes, Parawai's comment we have received.
Okay.
We'll be filing it. Your worship.
None appears on call for the petitioner. Heard Mr. M. Kato, the learned DSGI for the respondent number 4 and 6, and MS
Madam.
P. Sangeeta, the learned government advocate for the state respondent number 5.
Madam, I am for respondent number 4
4 and 6. Yes, 4 and 6. I have already.
I am for 5.
It is submitted by Mr. Kato that they have as per their affidavit, no, they submitted that as per the instructions, as per the affidavit filed by the respondent number 4 and 5 and as per the instructions received so far, the already altogether 4 numbers of cases has already been registered and the investigation is going on in all 4 cases. However, those are registered under the state state police of the Arunachal Pradesh. Mr. MS Sangeeta submitted in this regard that they have already, Parawai's comment they have already received regarding the status of the cases, and she need some more time to file their affidavit in opposition, bringing the status of the case as well as bringing the status of the stages of the investigation of all the 4 matters, all the 4 cases. In view of this, how many weeks you need?
3 weeks, Your worship.
Accordingly, let the matter be listed after 3 weeks, enabling the state respondent to file their affidavit, bringing all the bringing the present status of the all 4 cases, which has already been registered. Okay then.
All right.
Item number 15.
51 numbers. Yes. 15.
My senior is appearing in this matter, Your Lordship, and-
Mr. Sakya.
Yes, Your Lordship. He has taken steps, Your Lordship. This is the record, Your Lordship, and my sister is appearing in this matter for the respondent.
Lordship, I have been instructed to enter an appearance for respondent number 1, 2, 3, 4, 5, and 8.
1, 2, 3,
4, 5,
4, 5, and
8, Lordship. So in the meantime, I'll file my wakalatnama.
As per the order dated 2105, now 1, 2, 4, 5. 12 and 19, 12 to 19 is also represented as per the order. Mr. Riram Ledanet, Senior Government Advocate, AP, accepts the notice on behalf of respondent number 12 to 19. Do you
Yes,
have any instructions in that regard?
their government, state of AP, Your Lordship, 12 to 19.
State of AP has already received 12 to 19. No?
Lordship. Riram. नाम रिफ्लेक्ट नहीं किया ना उसने 12 से लेके ना.
So you are the as a standing counsel.
No, Lordship.
So you are appearing on 1, 2, 1.
Private respondent, Lordship.
All are private respondents?
Yes, Your Lordship. They are private respondents. 1.
Oh, 19 private respondents.
Yes, Your Lordship. Altogether, 10 private respondents are there.
Altogether?
10, sorry, Your Lordship, 11.
19.
11 private respondents.
Private respondents, 11.
Yes, Your Lordship. 1 to 11 are the private respondents, and respondent
1
number.
to 11 are the private respondents.
Yes, Your Lordship. And 12,
And 12 to 19 are the state.
State, Your Lordship.
So you have the instructions to appear for 1, 2, 3, 4, 5, and 8.
Lordship. As on today, 1, 2, 3, 4, 5, and 8.
Heard Mr. Here, Mr. Ibam.
Yes, Your Lordship.
Heard Mr. Ibam appearing on behalf of Mr. R. Sekia, the learned counsel for the petitioner. Also heard MS and Anju, the learned counsel appearing for the respondent number 1, 2, 3, 4, 5, and 8. And it is submitted that she has the instructions to appear on behalf of those respondents. And also you are appearing, na?
Yes, sir. 12 to
P. Sangita appearing on behalf of state respondent number 12 to 19 is there.
19.
Sir,
19.
Power Department, they have their own standing council.
So you are appearing for 12 to 17.
17.
12 to 17.
15 Power Standing Council.
Yes.
So what about 18, 19, Mr. Bam?
There is a standing council for this.
For RWD also, there is a standing council, Your Lordship. For
Yes, yes.
respondent number 19, it's RWD.
18 and 19.
And 18 also, they have standing council, Power Department.
No, it's okay. Whether they have received any, because in the last occasion also, there's no such note that they have appeared. Likely to take considerable rules in question.
I will get the instruction whether they have been served with the copy of this petition or not, Your Lordship. I don't have the instruction, Your Lordship.
You have not instructed for
The
18.
Yes, 18 and 19. Whether they have been served with the copy of this petition or not.
As per the last order, it doesn't say so.
Yes, Your Lordship. So I'll serve them copy, Your Lordship, so that they'll appear in this matter.
Mr. Bam, the learned counsel for the appellant, also hereby asked to serve the notice as well as copy of the petition to the respondent number 18 and 19, who will be represented by the standing council. Can see standing council, what department? RWD.
RWD, Power.
Power, the stability and power department.
Stop. But now, if we don't have any instructions regarding 6, 7,
Yes, Your Lordship.
6, 7, then 9
9 and 10, 11.
and 11.
6, 7, 9, 10, and 11. I have no instructions.
No instructions. Lordship. So then, will we abated for the service?
Yes, we will be able to.
Further service be abated for the respondent number 6, 7, 9, 10, and 11. Matter be listed after 2 weeks.
Obliged.
No, not 2 weeks, after 3 weeks, let it.
Obliged.
Item number 17.
Yeah, karena kan sebagai project.
Yes, 17.
My lord, the instant PIL is filed by the petitioner regarding.
Now, anyone is appealing for respondent number 11 to 17?
That is a private respondent.
Yes, private
That
respondent.
has not filed yet.
I'm appearing for private respondent, Your Lordship.
How many?
For all the private respondent. I have not filed my wakalatnama, but I will file my wakalatnama in meantime, Your Lordship.
No, but are the private respondents are from 11 to 17 or?
Yes, my lord.
10 to 17, I think.
10 to 17.
Yes, 10 to 17.
So you have the instructions to appear for
private
10 to 17.
Yes, Your Lordship.
All the private respondents.
Yes.
So you have not filed your wakalatama.
No, I will file in the meantime, Your Lordship.
So if 10 to 17 is there, already they have they got the instruction. And what about the other respondents who is appearing?
From 6 to 7, they have already filed affidavit. 6 to 8.
6 to 8.
The main respondents,
They have
first of all,
already
the officer authority has already filed, and I have received today.
RWD.
RWD.
They have already.
And the rest are almost not very much connected.
It's okay, but 1, 2, 3, and 4 are representing by someone you are representing.
I'm on behalf of Mr. B. Pecha, RD department. Respondent number 2, 5, 6, 7, and 8.
2,
Mm-hmm.
We have filed
5,
our
6, 7, and 8. You have
Yeah.
already filed.
Yes,
You are representing the 2 also.
2. Yes.
2 also. Acha. For B Picha, you are appearing. On behalf of B Picha, you are appearing.
Yes, my lord.
Now, 1 is the government, I think. Yes. Mr. Nabam, are you
Yes,
going to appear here? 1,
My lord, 1, 3, 4, and 9, my lord.
1,
My lord,
3, 4, and 9.
yes, my lord. The affidavit filed by the deputy commissioner, my lord, that will suffice, my lord.
Who is the deputy commissioner for item number 4?
Yes, ma'am.
You have already filed.
Yes.
4 has already filed. No?
My lord, I have not received. I have not received yet.
We have not received this. Advocate has been served. Service copy of the petitioner advocate has been served. 24/9.
Received by?
God no.
4 has already filed.
Yes, my lord.
4 has filed, but I have not been served. I have not been received.
My lord, I'll check that, my lord.
As per the office note on 24/9/2025 office note,
Correct.
they have already filed.
Correct, madam.
Okay,
So,
if they
not
furnish
before
another
this.
one more copy, that's
Do that.
Okay, sure.
my lord,
So then service is almost completed.
completed. So,
You need some time to file wakalatnama as well as you're going to file the affidavit also? Yes. Okay.
my lord, Council for the RD was informing me through telephonic, as he said daily. So he will be available by 10th.
So he is requesting me for to matter to be fixed on 10th. So otherwise we can take up today, or we.
No, let them file Wakalatnama. They have not.
In the meantime, the affidavit may be Bakalatnama and affidavit may file within that period of time.
I cannot say. Will it be possible on your part to file your affidavit within 10th of this month?
Yes, Your Lordship, I will try to file.
10, today's what? Today's 4.
To see, because some council is saying they're appearing from the outstation. You do one thing. She may require, because all of the private respondent may require some time to file their affidavit in opposition. In that case, if it is fixed on 10th, it may not be possible on her part. So we can fix it on 10th. Your council may appear through virtual mode also. Hearing may not be possible on that. That's what I'm saying. If it is now, what you want to submit? You need some time, or by 10th, it will be able possible on your part to file your affidavit.
Malad fix on 10th. ACS inform and let him.
Forget about the information. That is information from your council. That is not the information from the court.
I need some.
Otherwise, if Lordship permits, then matter can be taken up today also, because this is a law.
How can it be today? She is appearing for the private respondents they need some time. They have not filed the Wakalatnama till date. The matter was still awaited for the service. Now they have appeared. It's okay. Service is completed. But as per your direction, as per your council's direction, it cannot be fixed. No?
Yes.
I'm just asking her that whether it will be possible on her part to file the affidavit opposition within 10. If it is possible, then definitely we'll make him fix it.
Your Lordship, when it fix on the 10, I will try to file my.
You will try to. Definitely. It can be fixed. It can be fixed. Okay.
Okay, then my lord fix on 10.
You're Mr. M. Nibo?
Yes, my lord.
Hi, Mr. M. Nibo, the learned counsel for the petitioners.
Dispose of epidemic.
You are Mr.
T. Kamchi.
T. Kamching, appearing on behalf of
B. Pecha.
B. Picha for the respondent number
2, 5, 6, 7, and 8.
Second, 2,
5,
5,
6,
7, and 8.
Yes.
7 and 8 on for Mr. B. Picha. The learned standing counsel RWD, and also heard Mr. N.H. Navam, the learned additional AG, appearing for the respondent number
1, 3, 4, and 9.
1, 3, 4, and 9.
4 and 9.
It is submitted by Mr. Navam that they have the respondent number 4, that is the Deputy Commissioner, has already filed their affidavit in opposition, and that will cover the other respondents. Further, it is submitted by Mr.
T. Kamchi.
T. Kamchin that they have also filed their affidavit in opposition for the respondents. MS Rimana, Rimi, T. Rimi, entered into appearance for the respondent number, private respondent number 10 to 17.
Yes.
10 to 17, and she submitted that she's going to file the Wakalatnama on behalf of the private respondents and needs some more time to file their affidavit in opposition. However, it is submitted by Mr. Nibo that he has not been provided with the copy of the affidavit in opposition filed by the Deputy Commissioner, that is the respondent number 4. The Mr. Navam is accordingly asked to provide the same to the petitioner side. Considering the submission made by learning counsel for both sides, let the matter be listed on 10/11. 10/11. Enabling the private respondents to file their affidavit of opposition, if any. Okay.
Most obliged.
Item number 18.
May I please, Your Lordship? This is a jail appeal, Your Lordship. I have not received paper book, Your Lordship. Necessary direction may be given to the registry if the paper book is ready.
It's not prepared. Paper book is not yet prepared. We'll give a direction.
Yes, Lordship.
So you are the legal aid counsel?
Yes, Lordship.
Heard MS K. N. Maling, the learned legal aid counsel for the appellant. The TCR has already been received, but it is seen that the paperwork is not yet prepared by the registry, and accordingly, the concerned section is hereby directed to prepare the paper book. And after preparation of the paper book, the matter may be listed accordingly.
Yes, obliged, sir.
Item number 19.
May it please your lordship. So, though today it has come for orders, and it seems that private respondent number 6, AD card has come back without any indication therein.
AD card has
May, Your Honor. Actually, I'm for the respondent number 6, and on the last occasion.
Appearing for the respondent number 6.
Yes, on the last occasion also I was there. That order has been reflected wrongly. That
No, I think
it's actually
maybe 7.
Yes, Your Honor.
The AD card for respondent number 7 has come back without any indication therein as to why it has come back. But be that as it may, I have something to place before lordship regarding this matter. So,
No, service of the respondent number 7, this AD card has returned back. Without any
comment therein in the AD.
Acha.
So it seems probably the organization is not, this is a private organization against which we have certain disputes. But our basic case is against the government, the inaction on the part of the government. So to that aspect, I have certain issues to submit for lordship. So, but
If it has not been filed. No affidavit.
that is another aspect. No affidavit has been filed till now.
No, Lordship, for the Deputy Commissioner, the affidavit is ready, but then for others, you have not given me.
You have ready or you have already filed?
Extra copies. No, filed.
Affidavit
It's
is
to be
ready.
filed. Yes, it's
Ready, yes. And for 6, what is your position?
No, Your Honor, we are not ready.
Pardon? The affidavit is not.
No, not yet ready.
Not yet ready.
Yes, Your
Honor. That's what I'm asking.
Also, the issue is basically something that deals with a particular community, the Nisi community, and dealing with their own cultural rights and customary rights. So now it's regarding a particular festival. This festival is coming in the month of February 2026 again. So the scope of that dispute again arising is very much there. So I would therefore request the other side.
Now he is saying that if the festival, regarding that festival or the community to community, the matter issue is being raised.
Lordship.
So if it is fixed on the month of February, then time is very short. Suppose today, though, we are the mid of, say not mid of, but the first week of this November. So say November, December, January, 3 months is there only. So it has
Before that, it has to be settled. So I was requesting the other side that the affidavit should come as to what is the stand of the government. But ultimately, our case is we have a right under Article 29(1) to conserve our cultural rights and customary rights, which seems to have been eroded, which seems to have been infringed in the last occasion regarding this festival. There's basically a festival called Nokom Yolo, where a ritualistic part is also involved. Now, what had happened on the last occasion, every annual festival, what had happened was that the other faction who does not believe this indigenous belief, they don't have that indigenous belief affiliation, they say that this time we'll be celebrating the festival, but without the rituals. So therefore, just like Durga Puja in Assam, we have the cultural aspect as well as the ritual aspect. So we will have the cultural aspect, but not the ritual aspect. So this is a dispute. So what had happened on the last occasion, the last time, 2025 February, this has happened. And there was a lot of disputes and a lot of situations also occurred. Now the same situation will occur this time also. The potentials are there. So therefore, we had filed this case asking the state to intervene to create an environment so that we can protect our rights under Article 29(1). So therefore, I would request the state to take a proactive step, file their affidavit, and place before this honorable court their stand as to how they are going to protect us. So therefore, again, this festival is coming in February 2026. Before that, we want some solution in this matter.
I'm sorry. From the Deputy Commissioner, this will not suffice. It has to come from the government also, and he have furnished me only one copy.
One copy?
Yes.
One copy. We'll serve. If copies are required, we'll serve. That is not an issue.
Please another one copy to send it to the government.
No, but now you're appearing for the respondent number 1, 2. 1, 2,
Lordship, it is
3.
1, 2,
1,
3,
2,
4,
4 and 5.
4 and 5. 4, Lordship.
You are appearing for 4 and 5 only.
4 additional.
Additional
is
deputy
4,
commissioner.
Lordship.
Huh?
4 we have, is ready. But
No, no,
before-
your affidavit is ready for 4.
4. Lordship.
4 and
Only
5 also.
5 will be
Yes.
under him only. So
Under him only, yes.
Mm.
4 and
And the
5, maybe 4 and
5.
4.
4 and 5. But then at least from 2 and 3, it has to come, Lordship.
So for 2 and 3, you are not representing 2 and 3.
I am representing, but then I have
You
not
need
been
the
furnished
copy.
any copy.
Acha.
that is not an issue. We'll give them a copy. Yes, yes,
Extra
that will be
copy you
given.
need.
That will be given
Extra
today itself.
Yes.
Not an
So,
issue.
and but then otherwise, you are appearing for 1, 2, 3, 4, and 5.
Yes.
Otherwise,
Yes.
and 6 you are appearing,
Yes,
and
sir.
7 it has returned.
7
But
is that
without-
opposing faction. It is an organization of the opposing faction. I do not know whether they are registered also or not. But since maybe they will be necessary party,
But
so
there
that
will
may-
be necessary party if there is a.
that is
opposing
that is
faction
why
suppose.
that is why we have made them a party. But I do not know what the status of the service because the AD card doesn't reflect anything.
এই AD card খন ক'ত আছে?
The office note only indicates that the AD card has returned.
Without any endorsement.
Seems so. That's what is in there in the office note.
That's not.
So if the AD card physically could be seen.
Is it returned back, but still awaited.
Yes. So return back. There has to be some comment on that.
It's-
তারপর AD card টা ক'ত লিখো? কিবা লিখা আছে কি লিখা আছে? Dispatchers, একো নাই দেখোন লিখা। আমি কি লিখি দিই এইটো?
If they have refused to accept it, that will be
কি লিখি দিই?
Receive করবেন, receive করবেন, signature করবেন।
NH Tapa. কিন্তু টাবালৈ যোৱাই নাই দেখোন এইটো এছ'চিয়েশ্যন
Taba.
This was an association. Secretary, oh, acha, Secretary Mr. NH Taba. It seems
ma'am.
to be served on that
Seems to be served.
because Edika returned with an endorsement of the wife of Mr. H.N. Taba.
Then
Is considered
then-
to be
then
the
it-
general secretary of that association.
yes.
Endorsement.
Endorsement is there.
Then service is complete in my humble respect, Commission Lordship.
Item number items. Item number 1. Item 19.
6.
You are Mr. Sharma, no?
A Sharma.
Heard Mr. A. Sharma, the learned counsel for the petitioner, and also heard MS E80, the learned senior government advocate, appearing for the respondent number
125 Lordship.
1 to
125.
1 to 1 to 5, 1, 2, 3, 4, and 5, and Mr.
Tau Tahar.
Tau Tahara,
Yes, Your Honor.
appearing on behalf of
6.
private respondent number 6.
Yes, Your Honor.
Poster. Further, from the office note dated from office note dated 20/09/2025, the AD card in respect of respondent number 7 is received back, and on perusal of the AD card, it is seen that it has been served to the of the said association. However, the service report from the process server is still awaited. Next para, MS Ete, the learned senior government advocate, submitted further that the affidavit is ready for the respondent number 4 and 5. However, she submits that one more copy of the petition may be served to the respondent number 1, 2, and 3 for preparation of the
For taking steps, Lord.
for
I
taking
haven't
for
taken
taking
steps
for
to the
taking proper steps.
2 and 3.
Accordingly, the learned counsel for the petitioner is hereby asked to provide an extra copy to the number 1, 2, and 3. You need some time to file your affidavit?
Yes, Your Honor.
May I submit? Let the matter come up on 8th of December. They will have ample time till then for admission hearing. And by that time, let everyone file their affidavits. We are serving copy today itself to them, so that it can be decided accordingly on 1st of December.
Accordingly, Mr. Sharma is hereby asked to serve the copy within the course of the day. Further, it is submitted by Mr. So-and-so appearing for the respondent number 6 that he needs some more time to file their affidavit in opposition. Affidavit in opposition. Full stop.
8 is like
Mr.
Mr.
Nextbara, Mr. Sharma further submitted that the urgent hearing is required in the present case as there is a probability of arising same situation maybe in the month of February at the time of the festival. In view of this, all the parties are hereby directed to file their affidavit in opposition within 6, you are saying?
8th of December, I am saying, for fixing the matter, but before that, let them file.
8th of December 2025 in the admission column, and the respondents are accordingly directed to file their affidavit in opposition on or before the next date of listing, so that matter may be heard on the 8th of December.
Yes, Your Lordship. I'm obliged, Your Lordship.
You furnish the copy today itself.
Yes, we'll do that. We'll do that.
Item number 23.
My lord, I am representing on behalf of leading counsel Dioka, Miss Dioka.
B?
Dioka.
No, here SB Darang is there.
Yes, Darang is absent today. PP is absent today.
Now you are representing whom?
Dioka, leading counsels actually in this case.
D. Yoka.
Yes.
She is the engaged counsel or?
Engaged counsels actually, yes.
So names of this MS V Darang is also there. Or they are not the legal aid counsel?
Yes.
They are the engaged counsel?
Yes.
Okay, by the appellant.
Yes.
You are ready for hearing? We
Yes.
may inform the other side, the PP.
No. Actually, leading counsel instruct me to appear before this honorable court today itself. So I think PP is absent maybe.
I don't know, PP may be available. We may, additional PPs are there, you can instruct them.
You do the hearing?
No.
If you are interested, you tell your, what about you?
Actually, in this case,
We can inform the other side, that means with PP we can inform. Yes.
No. In some time may be given, my lords.
So that is mean you are praying for adjournment also,
Yes,
because otherwise PP office is there, we can inform, very well informed by them. It is okay then. So your good name?
El Rui.
L?
Rui. Yes.
Heard Mr. L. Rui appearing on behalf of D. Yoka.
Yes.
Mr. or
Miss Dioka, Miss.
MS D. Yoka.
Yes.
For the appellant and prayed for an adjournment. Paperwork is ready. Let the matter be listed. To how many weeks you need?
At least 3 weeks maybe given.
3 weeks?
Yes.
It's a 2019 matter.
Yeah. Actually, my lord, in this case, this case, in the last occasions, the dishonorable court sent a LCR report, and this case was pending before the session court UPR. Some witness has not been examined yet, Your Honor.
This is an appeal.
Yes.
Against conviction? Or
Yes. Appeal against convictions.
Then the witnesses are still examined.
Yes.
Examination of witnesses are still going on.
Yes, there are some witness maybe.
I'm not following you. What you have said, submitted, Mintre? Office of Reflect, the record was returned. Or say it was record was returned.
Yes.
to the Court of Sessions, UP as directed by this court, however, nothing is reported as per the order.
10 year, yeah, life imprisonment.
Oh, status was called for.
Yes, yes.
So now what is the status? We don't know.
Yes, we don't know.
Recording additional evidence has submitted that only out of 15 numbers of witnesses, 14. huh? কি কৰিছে গম পোৱা নাই? এইটো ইয়াতে কিয় ৰাখিছে তেতিয়া?
In this number of, oh, I see. Additional evidence was directed to.
Yes, yes. Additional evidence.
But in the
14
appeal,
numbers
Yes.
of witnesses have already been examined. Only one witness is to be recorded.
appeal additional evidence record কৰিব দিয়া যেন লাগিছে মানে।
সেইটোৱে কথা,
391 CRPC.
But anyway,
So,
out of
that's why it's
15, 14, as per the order of 21/05/2025, out
Yeah.
of 15 numbers of witnesses, 14 has already been examined
Yes, yes.
as per the report. But now, today, the additional PP is absent. I
Yes.
don't know.
Status reported ভালো on the learned trial court.
So, heard Mr. So-and-so appearing on behalf of MS so-and-so. The PP is absent. However, from the order dated 21/05/2025, it seems it is seen that out of 15 numbers of witnesses, 14 numbers of witnesses have already been examined. But due to absence of the learned PP, the status of the present case is not available before this court. In view of Nixpara, in view of this, the learned PP, public additional PP is hereby directed to furnish the status report of the case on or before the next date of listing. And
This is the order, the direction is 7/4.
তাৰপিছত এইটো কৰিলে
Yes.
next date of listing on or before the next date of release accordingly after 2 weeks.
Right.
Okay, we look seeking the present status of the case. Today PP is not available, so we
Yes,
are not in a position to say anything. May be completed within because out of 15, 14 has already been recorded.
Hmm.
So by that time, it has already been completed. Maybe.
Hmm.
Okay.
Much.
We will listing it after 2 weeks
Yeah.
as on a date to be fixed by the registry. Okay.
Item number 26.
Yes.
Lordship, I'm from respondent number 2 on behalf of the council for respondent number 2.
Yeah, for the
T-
respond number 2.
Yes, Your Lordship. Mr. T. Getso.
Yes,
So,
T.
T. Getso. Yes, I'm here on behalf of him. So, Your Lordship, this matter may be listed after 2 weeks. Council is already taking a matter in another courtroom.
Yes, Mr. Tapak, what do you want to
Yes,
submit?
all right.
Right. Heard Mr. T. Tapak, the learned counsel for the appellant. The PP, oblique additional PP, there is no representation of for the state respondent. However, you are Mr.
T. Gamo.
T. Gamo appearing on behalf of Mr. T. Gesto for the respond number 2, oblique the legal aid counsel, has submitted that Mr. Gesto is prayed for an adjournment. Submitted prayed for an adjournment. Appearing on behalf of so-and-so prayed for an, to which Mr. Tapak raised no objection. List the matter accordingly after 2 weeks will do?
Yes, Your Lordship.
3 weeks.
2 weeks.
2 weeks. List the matter accordingly after 2 weeks as on a date to be fixed by the registry.
Lordship, very sorry. Item number 31 also, that maybe adjourned because judgment is not ready. All the matter is
Item
this
number
body, item number 31. 31.
31.
Yes.
Then
Can this matter be adjourned? This is my case.
Judgment,
Yes, item number 31. 31.
which judgment not ready?
Because government is also not ready because some citations will be required, sir, to hear the matter.
government is not ready.
Yes, government is also.
No, she will submit whether she is ready or not.
I have
My
discussed.
consent, I said, you try.
Yes, we can. Then we can proceed also.
He
If
said he
government
wants
is, if
to
government is
come up
ready.
with some judgments.
Yes.
So he
Yes,
wants
that
the
is right.
judgment, he said. So I said, okay. It's up to you.
Government is ready, yeah.
Government is ready, then it's, it's all right. And we will, we will go for hearing. Yes. Or the next, let the next.
No, you
next-
want to provide some judgment or you want
Yes,
to
I want
get
to provide-
prepared yourself. But
Yes.
the problem is with us that today is the most probably 2 days we are having the division bench. Tomorrow is a holiday.
That is right.
Thursday and Friday will
After-
be the single bench.
Can this matter be fixed?
So
after
if
one-
I
one week?
part heard the matter, that will be again
Yes.
inconvenient for the court also and for the personally also. Because constitution of the division bench with my brother will not be possible within this next month.
Yes.
So in that case, if you need some time for preparation
After 1 week.
after 1 week.
Yes.
Okay then. With the consent of the other side, the learned counsel for the appellant, Mr. T. Tapak, plead for an adjournment. Prayer allowed, please the matter after a week,
After a
after a week, as on a date to fixed by the registry.
Obliged.
Okay. Obliged.
Item number 30.
Yes, 30 is criminal appeal.
Yes, my lord, the
Now.
amicus is
they are
here.
absent.
No,
Amicus?
the legal aid counsel is there. The learned PP requested me, sir, you go ahead with your argument and he'll come and join us.
Oh, acha, they will join.
Yes.
So you are for the
My lord,
number 2.
Yes,
As a legal aid.
Yes, my lord, I am for the victim, my lord.
my lord, there is one IA also.
10 minutes I'll hear and then again at 2.
Yes, my lord, that in the meantime,
Yes,
I'll
you can
demonstrate. My lord, kindly see, we have made a mention for listing of the IA also. In the event, if this final hearing is not concluded, then the suspension of the sentence might also be taken up. Anyway, my lord,
Order of suspension is there, suppose.
yes.
In that case, hearing of this case will be maybe taken up in 2030 or 2031.
I'll not. My lord, my lord, in any case, my lord, last night I have attempted a written argument that is yet to be refined. But once I complete my argument, then I'll furnish the copy with the refined version, my lord. So, my lord, the present appeal is preferred against the impugned conviction order dated 23rd January 2024. Sorry.
That's okay.
No, good case.
मैं आपका विषय सीनियर के सामने में इतना तो पता होना पड़ेगा
I'll do.
Hey, Hedi, Sharma. Central Institute, yeah, Central Institute. Central Institute. Yes, yes.
Yes. So, my lord, this present appeal is preferred against the impugned judgment and conviction order dated 23rd January 2024 in session case number 8, 2021 for offense punishable under section 302 IPC and section 27(1) of the Arms Act 1959. And my lord, the appellant has been convicted to undergo a life imprisonment, my lord. Now, my lord, to bring home the guilt, my lord, the prosecution has examined as many as 16 prosecution witnesses, my lord, comprising 7 officials, witness, of which 5 are police personnel and 2 are government experts, doctor and forensic scientists, 8 civilian witnesses, 1 court witnesses, and 2 defense witnesses, my lord. This is
That is altogether 9.
yes. altogether 16, my lord. Now, my lord, when I laid my hand on this particular appeal on being engaged, I understand that this conviction is not sustainable, my lord. Not sustainable as it is vitiated by material, my lord, contradictions. One. Number two, procedural.
Material contradictions.
Yes, material contradictions. One. Number two, procedural illegality and misappropriation of misappreciation of evidence, and purely based on circumstantial evidence, as there are no ocular evidence in this case. To my mind, my lord, the reasoning of the learned court below is internally inconsistent and contrary to the established principle of criminal jurisprudence led by this honorable court, as well as in Katina of decisions by the honorable apex court, my lord. Now, my lord, for a moment before I take my lord to the fact of this case, my lord, kindly have a little glance over the index. I'll point out 1, 2, 3 things, my lord.
Yes.
My lord, number 1 is the FIR. Number 2 is the FIR under section 154, exhibit, my lord, final form report, my lord. I am posing here. So my lord has seen 2 things. First, 161 statement is not there. 164 statement is also not there, my lord.
Come to the later part. If
No, just yeah, my lord, just I am pointing out because on this basis, on this premises, I am going to start my argument, my lord.
Okay.
So, my lord, first ground, my lord. Before this, my lord, just I want to point out, then I'll take my lord to the annexures, my lord. My lord, the first ground which I argue would be absence of disclosure agreement, my lord. Their statement, my lord. So therefore, my lord, I was taking my lords to the index first, where these documents are not available, my lord. Absence of disclosure statement, a mandatory requirement under section 27 of the Evidence Act. Recovery legally inadmissible and factually unreliable, my lord. Now, my lord will put the heads towards section 114A also, my lord, straight away of the Evidence Act. Now, my lords, these cases rest entirely on the circumstantial evidence, my lord. There being no ocular testimony whatsoever. Now, my lord will kindly come to, yes, I make this particular submission, my lord. In paragraph, my lord will note this. In paragraph 17 to 19, my lord.
Of judgment.
Of the impugned judgment, my lord. This internal page 10 and 12, my lord.
Ten and 12.
10 and 12, internal page, my lord. 10 and 12. Page number, my lord, in paper book, my lord will find at 79 and 81, my lord. In the paper book, 79 and 81, my lord.
Yes. 79, para.
My lord, in para 17 and 19. Before I take my lord to this particular paragraph, let me make small submissions, my lord. Then I'll indulge. Now, my lord, the principal circumstances relied upon by the learned trial court is disclosure statement allegedly made by accused under section 27 of the Indian Evidence Act, which purportedly led to recovery of the weapon of offense, a 3.315 rifle said to have been used in the commission of the offense. Now, my lord, before I take my lord to these particular pages, my respectful submission is that before any reliance can be placed upon section 27 of Indian Evidence Act, my lord, the prosecution must first establish that existence of a lawful, voluntary, and admissible disclosure statement, my lord. Now, my lord will kindly try to recall Rajiv Fukan, my lord, judgment, our full court decision, my lord.
Yes.
It's clear. If you do not reduce into writing, this conviction is not sustainable. I'll place that judgment, my lord. So, therefore, my lord, what I am trying to impress, my lord, is this was never reduced into writing, never signed, my lord, by the accused, and never exhibited in the court, my lord. This is conclusively established, my lord. My lord will mind that, then I'll take my lord to those depositions. These, my lord, to my mind, my lord, conclusively established from the deposition of PW8, that is the officer in charge, my lord. Officer in charge. My lord, in these 10 minutes, I'm giving the outline, 3 points where I'm going to rely on, then I'll take on, my lord. Now that officer in charge, my lord, paper book, my lord, 52, in the cross-examinations, my lord. Will just mark, my lord will mark it, I make this submission and then I'll rely on. Who categorically admitted that no disclosure statement was recorded. He stated only that accused, upon being apprehended, orally mentioned that the rifle was kept in the jungle. But no written statement was made. Now, similarly, my lord, PW15. My lord, PW15, my lord, is the first IO of this case. First IO of this case. He also makes the submissions. Paperbook 61, my lord, we'll see. Paperbook 61 to 63. I'll cross-examination, I'll take, my lord. Admitted that no disclosure memo was prepared. No written statement was taken from the accused. The accused was never produced before. My lord will kindly mark this in this. It's very critical, my lord, page 63, my lord. In the, he says, no written statement was taken from the accused. The accused was never produced before a magistrate for a confessional statement, my lord. Now, my lord will kindly have this mind. Now, 161 statement. Then, my lord, 161 statement, CRPC will follow 162. And thereafter, my lord, although these are not substantial piece of evidences, but the requirement under 164 is also very important, my lord. So this is their prosecution case, my lord. So which they say, it's very unfortunate, my lord. Despite this, my lord, what it is paining me is that despite these admitted facts, my lord, the learned trial court in paragraph 30, my lord, just I have written in my hand, my lord, paragraph 30 at page 17 of the impugned judgment, my lord will find in paperwork page 86, my lord. Erroneously place reliance on the alleged oral disclosure, which is wholly impermissible. Now, my lord, law is well settled and consistently enunciated by Honorable Supreme Court authoritatively that under section 27 of the Evidence Act must be recorded in writing, signed by the accused and duly proved and exhibited in the evidence. Now, these three particular evidence, my lord, are missing in this judgment, my lord. Impugned conviction order. Now, my lord, that Emperor judgment 1947, I'll place it after some time, my lord. Just time is short, so I'm making the brief outline of my argument.
We'll hear it too.
Yes.
It's okay.
Yes. So therefore, my lord, even in the Bankatas judgment, my lord, Karnataka, 2005, 7 SSC, page 1714, my lord, I will provide in writing, my lord. My written argument will be there. Fully, I will give a comprehensive one, my lord. Now, my lord, therefore, that 2019, if you have this, kindly this Rajiv Phukan judgment. Yes, I'll convince my lord that full bench, Rajiv Phukan judgment.
Okay, then this we may continue at 2. It will be continued at 2.
Yes. Okay. So, my lord, that is one thing, my lord. Second thing, my lord, second ground, my lord, just I'm putting 2 more grounds.
Yes,
in short, I'll not take time, my lord.
Okay.
My lord, see, there is a violation of section 173 CRPC because that is non-forwarding of case diary and section 161 statement, my lord. Nothing as such. This is second thing.
No. Why you were saying that those were not sent 161 or?
It is there. It is there in the record, my lord. I'll come to that. I'll expand and explain, my lord.
No. At the time of this investigation, 161 was recorded, I think.
No.
There was no record.
No record at all, my lord. 164 even, my lord. And the disclosure statement is also not there, my lord.
No, it's okay. Disclosure statement may not be there. 161 and 164 was 64.
No, my lord, it was not
recorded.
No, no. My lord, the one important aspect which I'm putting to my lord's mind is that, my lord, kindly see the charge sheet, my lord, was filed by a retired officer, retired IO of the case. And therefore, my lord, the question of cognizable jurisdiction and the proceeding is unsustainable, my lord. My lord, I will not detain. I'll come back at 2 and then I'll place my case. Then I submit my written argument. And my lord, there are so many, my lord. Even there is even the ballistic, though my lord, the ballistic expert has said he was not provided with the bullet which shoot and kill the deceased. He was not sent for the, even the doctor also says, my lord. So therefore, ballistic and all those. Lord, I'll
But
come back.
ballistic expert was examined, I think.
He was examined. He clearly deposed, my lord.
Okay,
I'll come, sir.
Okay. You got more down here.
Now the
So, Mr. Tanu, we have heard some three, 4 points from Mr. Tara.
now now the quorum is full.
Now, yes.
My two learned friends. So, my lord, I was on the ground one. Now, I'll take, my lord, straight to the pages which I was referring to, my lord. Then I'll place the judgment. Now, my lord, kindly come to page 79.
Can we see the FIR? Just
Yes, my lord, that I thought of
no, just that page 1.
page 1, my lord, FI. First, 2/7/2020. So my lord has seen. 2nd July incident occurred on 1st, and 2nd July the FIR was lodged. Now, my lord, kindly see the FIR on the
साइड हो गया थी कल उसमें काम भी नहीं सकता इतना हैवी है मतलब
my lord can
थोड़ा थे बस बस
my lord can see page 6 and 7 as well. Mama, charge sheet, page 8. Final form report, my lord. So, Ekta no identify Madhya. He has not said something. Charge sheet. My lord, if permits, may I read the charge sheet?
Charge sheet.
Yeah, it's important for us, my lord. I'll start. Lord, I'll start reading from page 6, column 15, my lord. The result of laboratory analysis, Exhibit A was used for firing some times before it was received in laboratory. 2. Exhibit A is a regular 0.315-inch caliber sporting rifle manufactured by so-and-so. It is working order. In its present condition, test fire conducted successfully. Exhibit is so-and-so inch caliber empty cartridges, and it has been fired through Exhibit A. Exhibit LR2 and LR found to be in live before test firing in a laboratory. The remaining cartridges marked as so-and-so resulted to misfire through so-and-so. A fire is part of ammunition agreement or ammunition as defined in the Arms Act. The brief prosecution story of the case is that on so-and-so, one Sri Asang Kasidu, 27 years age, so-and-so, of Nafra Blaze, to the effect that in the intervening night of 1st and 2nd July 2020 at about 21:30 hours, one Sri Sang Narbu Saidu, late of so-and-so, armed with gun came to entry gate of screening point and shot down one Sri so-and-so. As a result, Dobo Kasidu fell down on the 4 Junction PWD Road, Saddle, and found dead on the spot. On the receipt of the FIR so-and-so register, the case has been taken up by so-and-so. My lord will mark this. L. Sharma, PW 15. He is the first IO of this case, my lord. During investigation, the IO visited the PO and examined the available witness. 1. No empty cartridges fired with 3.315 rifle. Witness. No live cartridges of .35 rifles were seized by the IO on this. But this is very important, my lord.
No. It is one number.
No, my lord.
One number empty cartridge.
No, one number. But I don't know, because otherwise, if I read like this, subject to correction, my lord.
One
Anytime we can.
one
No,
number.
it's one number.
One number.
One number.
One
NO
number.
dot
No live and one number live cartridge of rifles were seized by IO on
0.315.
Yes. The accused Sang Nabu Saidu had left the PO after shooting that the deceased towards jungle side before reaching the police. Inquest held over the dead body. So-and-so village Nafra, Arunachal Pradesh, and later forwarded to C. Nafra PM. After conducting PM, the dead body handed over to his near relative for his last rite. Accused so-and-so, village Koina Nafra, AP, has surrendered himself. My lord will mark this because the PW 15 says he has arrested him, and PW 8 says he has surrendered. 15 says he has surrendered. PW 8 says he has arrested him. So this material contradiction is there with us. West Siang District, my last line, has surrendered himself before the police. Accordingly, he has been arrested in connection with the case. The accused was interrogated by then IO. On interrogation, he stated before the IO that he is Hunter. On 10/6/2020, he was called by Gunu Dijiso of the Ronrang village and asked him to go for hunting at Sangti area under Dirang. They went to Sangti in a car. On reaching Sangti, four more people joined with them. They all remained in the jungle for 2 days but did not get any animal to hunt. Thereafter, he and Gunu Dijo returned back to their home. While returning back, he took the rifle and 4 live cartridges with him to keep in his safe custody, but he did not know the actual owner of the rifle. After a few days, the Sartang Ili Society Committee members came to the house and asked him that where was he for the last few days. Then he narrated them about the past days. Then they told him to remain in home quarantine for 5 days. During those days, the committee members used to visit and ask for my needs. They wanted to extend the period of 5 days to 7 days. Hearing that, he got frustrated and remained quiet in his home. My lord, this is also important, this line. Remain quiet at his home. In the evening hour of 01/07/2020, he called Dobo Kasido to meet him, and on his reaching, he asked him to procure local wine. He bought 1 bottle local wine and they consumed 2.5 liters. Thereafter, Dobo Kasido went to his destination. He got more worried about the decision of the committee members and got angry with them. He took the .315 rifle, which he kept with him after coming from jungle, and fired a round on the air in his house, and then they approached the point of entry to Koina. There, a person was approaching towards him, and he thought that he was coming towards him to snatch the rifle. He was coming closer to him. This line is also important. He was coming, there was a person approaching towards him, and he thought he was coming towards him to snatch the rifle. He was coming closer to him, then he fired upon him, but he could not recognize that person, who he was. Thereafter, he ran towards Rurang jungle side and spent 2 nights in the jungle. He was much worried by thinking about that if he comes out of the jungle, then the people of the Saddle and the Koina would kill him, and he finally surrendered before the police to save his life from the people of Saddle and Koina. On leaving by, the accused alleged .315 rifle has been recovered from the Naku site with 13 live cartridges, and accordingly, the said rifle and cartridges have been seized and forwarded to the CFSL, Director of Forensic Science Service, Ministry of Home Affairs, Government of India, Kamrup, for chemical analysis through SP Bomdilan. During the further investigation, the honor of, well, this is very critical. I am going to correct this man. During further investigation, the owner of the .315 rifle, Sri Dongrik Miji, 57 years, son of late Lapa so-and-so, appeared before the IO at the Bomdila PS and produced his gun license number so-and-so. The license owner has been examined and seized the gun license, and later he has been arrested on 2020 in connection with the case and interrogated and recorded his statement in a separate sheet of the paper. The accused was produced before the court on 22/7/2020, and from where he has been enlarged on bail on same day. The owner of the gun, owner Sri Dongrik Miji, has stated before the IO that he was the legal owner of the rifle, registration number so-and-so, manufacturer of ordnance factory having license number so-and-so, which was with him since from his purchase. During the month of May 20, he, along with some relatives and cousin brother, have gone to Nafra for purchasing of cow meat for performing puja, taking his so-and-so rifle for personal safety. They visited the Koina village and also found a cow and got purchased. They halted a night there. Next day, they moved to Sapa. On reaching Sapa, he found his gun was not in vehicle. He immediately searched and inquired from his relative, and later, here the problem starts, my lord, about the gun. He forgot to take with him at the time of departure from Koina, and the gun was in safe custody with responsible person. He could not go to Koina to take his gun due to illness and lockdown due to pandemic COVID-19 in various areas. On 5th July 2020, he heard that a person has been killed by his gun. He also stated before the IO that he did not have knowledge that his gun was used by a person. During further course of investigation of the FSL report has been received, the Director of Forensic Science Service, MHA, Government of India, Urput Village, Kumera Road, PO, Maineri, Tinali, PS, Palasbari District, Kamrup, Rural so-and-so, through SP Bomdila, wherein AK Pal Scientist B. Blastic has opined that Exhibit 1 was used for firing sometime before it was received in the laboratory. B. 2. Exhibit A is a regular .315 rifle caliber sporting rifle manufactured by Indian Ordnance. It is in working order in its present condition. The test fire conducted successfully so-and-so caliber empty cartridges case, and it has been fired through A, Exhibit A 4, Exhibit LR2 and LR4 were found to be in live condition test firing in the laboratory. The remaining cartridges marked so-and-so resulted to a fire through Exhibit A. 5. Exhibit A is a firearm, is part of ammunition, and so-and-so. In view of above fact and circumstance, prima facie case under section so-and-so established against the Sang Narbu so-and-so, so-and-so, so-and-so. So, statement 7 no, seizure list 2, inquest report 2, dead body challan, and so-and-so has been given now. Now my lord has seen the facts in the final form report. Now the trial has started. Now, therefore, my lord, since I requested my lords to have a kind indulgence to the enactor a while ago, whether the disclosure statement was recorded or not, because the entire case is, my lord, premises on the circumstantial evidence, my lord. So, therefore, I would beseech my lords to kindly visit these pages, my lord. Now, my line of argument, my lord, is on section 27, that is absence of this disclosure statement. To my understanding, my lord, a mandatory requirement under section 27 of the Evidence Act, my lord. Recovery legally inadmissible and factually unreliable. That is what I want to argue, my lord. So for that, my lord, I beg to indulge my lords to paragraph 17 of the impugned judgment, which my lords will find at page 80 79 onward, 79.
Yes.
During cross-examination, this is PW8, Malad, the retired this thing. Malad, kindly flip back. That is his finding. During cross-examination, he deposed that he is illiterate. He has not drafted the FIR himself. He does not know the content of the FIR. He does not know the content of the seizure list. He has put his signature on the directions of the IO. He does not know the content of the inquest report. He has put his signature on direction of the IO. Everything, Malad, there is a influence with that. He has lodged the FIR on the suggestion of the villagers and nearest relative of the deceased must lodge FIR, hence being so and so. Now, para 19, Malad, para 17, Malad, of the impugn. PW7, Sri Sang Dorji Khadu deposed that he was, para 18, Para 18, I am correct. Duties at Seidel Gate from morning 6 a.m. to evening 6 p.m. with the other person, and this is on the day of the incident. He got slept, but suddenly he heard a sound of gun firing from the camp where they used to sleep. They heard a shouting voice of the accused just above their camp, stating that "Marega bola hai to marega." After some time, they came to know that the deceased was killed by bullet injury and the accident was reported to the police. He saw one live cartridge and one empty cartridges at at the place of occurrence. He exhibited PX1, the seizure list of so and so, so and so, so and so. Now, I'll not read complete. Kindly come to para 19. PW8, the retired police officer, which I would be relying on for filing the charge sheet. Sri P. Riziju, retired SI, deposed that he is a retired police officer. At the time of incident, he was OCPS Nafra. At 9 p.m., he received information through mobile about murder of a person at Seidel. Accordingly, he deployed ASI L. Sharma, the first IO of this case, to visit the PO. The dead body was brought at Nafra for PME. The accused was absconding. After the incident. Accordingly, he put the sources. He realized that the father of the accused was staying at Upper Dajang at Nafra, and he instructed his family members to inform him if the accused come at Upper Dajang. Accordingly, on 3/7/2020, he got information that the accused is sheltering at so-and-so, Alubari, in a field. He went to the field and apprehended. Kindly mark this. He said he has apprehended. PW15 will say the first IO, L. Sharma, he says he was arrested. Went to the field and apprehend the accused and brought at PS and detained him. On security reason, he was shifted to Bomdila UTP cell. On his ask about .315 rifle, the accused disclosed him that the .35 rifle kept in jungle. On 8/7/2020, on the leading of the accused, Malon will mark this on leading of the accused. The .315 rifle was recovered from the jungle in between Nafra and Naku Blaze. Accordingly, it was recovered in presence of DSP, Bomdila, and other police personnel. That means, Malon, no independent witness was there. Because when it is there, there must not be an endeavor. They should make an endeavor to bring the independent witness, which they have not done it. Now, para 20 is most crucial in this case. During cross-examination, he deposed that he is not the IO of the case. First thing, my lord, he is not the IO of the case. It is denied that the accused did not disclose him about the rifle. He has not recorded, my lord will mark this. It's very important for me. He has not recorded the disclosure statement of the accused. It is denied that they falsely implicated about the recovery of rifle. There were no civilian during the time of recovery. This is what I want to argue on this. I'll place the judgment at later point of time. Now, my lord will kindly see in the paragraph 21 also, PW8 Sri Panjan Riziju, during his further examination, is deposed after his retirement. He was called by OCPS Nafra, my lord. and asked him to sign the charge sheet as investigation of the same was conducted by him before his retirement. Accordingly, he has put his signature and charge sheet was forwarded by OCPS to court, exhibit so and so. Now, serious issues is coming up, my lord. Now, therefore, my lord, first I rely on one particular judgment, my lord. It is a latest judgment, my lord. Binoy versus 2017 judgment, my lord. It is reported in 2025 by Justice Oka, para 7 and 8. Tama? You have the copy. Kindly furnish that. I have this. Then thereafter, my lord, I will come to Rajiv Phukan, my lord. My lord will kindly come to page 6, my lord. The last paragraph. Thus, it is very difficult to believe. Thus, it is very difficult to believe the testimony of PW4 and 5 for the following reasons. The statement made by both the eyewitness that appellant inflicted 2 to 3 stab wounds on the back of the deceased with a knife are omissions. The version of PW4 that he was standing at a distance of 15 feet from the scene of occurrence is also an omission. Because, my lord, nobody has seen. There was no eyewitness, as I said, even no ocular evidence. So these are the things, my lord. Then para 8 is important, my lord, which I am going to rely. In this case, there are material omissions which amount to contradictions coupled with material omissions. If consider the conduct of both the witnesses, their version does not inspire confidence. Once evidence of these two witnesses is disbelieved, the only remaining evidence against the appellant is of the recovery of knife at his instances. The law relating to the evidentiary value of recovery made under Section 27 of the Evidence of Indian Evidence Act 1872 is settled by this court in the case of Manoj Kumar Soni versus State of UP. Paragraph 22, my lord, is reproduced, my lord. A doubt looms can disclosure statement per se, unaccompanied by any supporting evidence, be deemed adequate to secure a conviction. We find it implausible, although the disclosure statement hold significance as a contributing factor in unraveling a case. In our opinion, they are not so strong a piece of evidence sufficient on its own and without anything more to bring home the charges beyond reasonable doubt. Therefore, in our view, the appellant's guilt was not proved beyond a reasonable doubt. Is because that of the contradictory statement by the PW8 and the 15 itself. Now, my lord, Rajiv Phukan judgment, my lord. It's okay, that is reproduced there. No, that's GLT was. My lord is aware of this Rajiv Phukan ratio, whether the disclosure statement must be reduced into writing or not. Well, I just, no, that is what, this is what this is. Well, some of the judgments I have not printed, so therefore I will provide in my written argument, my lord.
Citation.
My lord will see that. My lord will see it is authored by Justice Ansari, my lord. My lord, the paragraph 1, my lord. Whether a statement which is popularly known as disclosure statement, must be reduced into writing in order to make such a statement admissible in evidence under Section 27 of the Evidence Act is the question which this reference has now to be answered. My lord, there were two. One was, kindly see paragraph 2, that the Pandab Koya versus State of Assam report in 2006 1 GLT. There's another division bench. And 2008, my lord, there were two contradictory views, my lord. So therefore, the reference was sent, my lord. Now, my lord, what is the answer of the reference court? My lord will find at paragraph 55 and 56, my lord.
This was a reference? Judge?
Yes, reference. Full court. Full court of.
No, not full, this
Full
Rajiv
court.
Fukan-
Full, yes, Rajiv Fukan is 3 judges. It's a full court.
Oh.
This is, I don't know, many times I have realized this judgment. Well, let us read paragraph 55 and paragraph 56, my lord. Initially, my lord, our full court was reluctant. It is not mandatory that it should be reduced into writing. But then it says, although it is a directory, but then it should be in the written formula. So paragraph 55 and 56. From the emphasized portion of the observation made above in Bodhraj Supra, it becomes clear that though the information which the prosecution relies upon to show that the accused gave the information which led to discovery of a fact should be recorded and proved it. But if it is not so recorded, the exact information must be adduced through evidence. My lord, here it is fit into the scheme of my case, my lord. Disclosure agreement, my lord, whatever is even not exhibited in this. Obviously, such evidence would mean oral evidence or some other evidence in the form of audiovisual or tape. Never, my lord. No video, audio, nothing, my lord, received from the records. Nothing is there. Nonetheless, what clearly transpired from the decision in Bodhraj Supra is that even when a statement leading to discovery of fact has not been reduced into writing, such a statement is still admissible in evidence, though the probative value therefore would depend on the fact and circumstances of a given case. Now our reference. Because of what have been discussed and pointed out above, we conclude that a disclosure statement to be admissible under Section 27 of the Evidence Act is not statutorily required to be reduced into writing, though the prudence, my lord, will mark. Though the prudence demands that such an information should be reduced into writing in order to enable the court to know exactly as to what the accused is allegedly to have stated, the extent to which the information given by him is admissible. The reference is then answered accordingly. Now, my lord, the law is settled by our own full court, my lord. It says here, my lord, two things, my lord, will see. The PW8, my lord, Mr. Rijiju and Mr. Sharma, PW15, both of them, they say that they have not reduced the disclosure statement into writing and it has not been executed. So therefore, my lord, to my respectful submission, my lord, is that this finding relying on Section 27 of the Evidence Act by the learned trial court, to my mind, is not sustainable, my lord. It is because, my lord, then, my lord, that Supreme Court, my lord, and AIR Emperor, King Emperor.
This actually, that's
my lord, please.
This 27, as I understand, the legal questions on this for the purpose of this kind of determination would be, I think, twofold. One is that whether it is essential, prudence, no doubt about prudence. Of course, it will be always desirable. Whether it is essential to record a statement under whether there is a mandate of law making it essential for a Section 27 statement to be recorded. Number one. Number two, whether a conviction can be based only on a disclosure statement. Next.
Yeah. The answer is, my lord, the answer is CR.
As we go on in the hearing.
Because the answer is, my lord, CRPC is a procedural law, my lord. So what is prescribed in the procedure, my lord, it has to be followed. If it is not followed, that means there is a denial of the right to fair trial. Now the procedure as prescribed, my lord, will find that Mahendra Singh Gill judgment, my lord. Therefore, my lord, that judgment I will put, my lord, if kindly write this Mahendra Singh Gill judgment, you keep it writing, because I am aware of this judgment, my lord. Mahendra Singh Gill judgment says, if the procedure is so prescribed, you must act according to the procedure. Any deviation would be void ab initio. So therefore, the meaning is procedure as established.
No, statutorily, it is not required. It is already stated.
No, that's why. That's why, my lord. So therefore, if two views are emanating, then the benefits should go to the accused. The decisions are there, my lord. So therefore, on this
You're saying
proposition,
that the prudence demands.
Prudence-
Not statutorily
No,
required, but yes, obviously
Yes.
you are saying that
Yes.
there should be the
It is always
forward
desirable.
piece of evidence is desirable. Okay.
I have to bow down whatever falls from their lordships. Because I believe, my lord,
No, we'll see the other evidence definitely.
We are engaging in a
And you have submitted that 164, 161, and that apart, the disclosure statement is not available. Initially, you have stated.
yes. So therefore, non-fulfillment of the procedure under section 27. See, my lord, then there is a very interesting thing. Where is the CRPC? My lord, will kindly see this section 100, my lord. CRPC, please provide. It's very interesting, my lord, when we come to the procedural law, my lord.
No, CRPC.
CRPC,
you're
old
giving-
CRPC.
All CRPC.
Yeah.
Okay, yes.
Very interesting.
Yeah, you can.
Pointing out section 100.
Section 100, my lord, the old CRPC. Person in charge of close place to allow search, my lord. Now this is, now thereafter, kindly see subsection 4, my lord. It is relevant to us instead of going too much here and there. Four, if my lords have married.
Yes.
Here. Subsection 4. Before making a search under this chapter, the officer or other persons about to make itself call upon two or more independent and respectable inhabitants of the locality in which the place to be searched is situate or any other locality, if no such inhabitant of the said locality is available or is willing to be the witness to the search, to attend and witness the search, and may issue an order in writing to them or any of them. Now, my lord, here why I am saying is for a purpose. They have not made this attempt also by their own admission in the cross and in the prosecution witness statement also. Now, my lord will kindly see 5 as well for a moment.
The incident took place at what time?
Incident took place at 9:30 p.m.
9:30 p.m.
9:30 p.m.
in the jungle area, na?
in the jungle area. And nearby, Saidal, and there, my lord will see. In the road, jungle. My lord, that's village is nearby. Within the village compound only it has happened. So this is discernible from the exhibits and the record itself. Now, my lord, kindly see the 5, subsection 5. The search shall be made in their presence, and a list of all things seized in course of such search and of the places in which they are respectively found shall be prepared by such officer. But here, my lord has seen already, they have deposed that they have not prepared the disclosure statement, and then the search also. or other person and signed by such witnesses. Here, my lord, will see when they went to recover the witnesses, my lord, it was all police personnel in the presence of DSP. So this VCS, my lord. But no person witnessing a search under this section shall be required to attend the court as witness of the search unless specifically summoned by it. Now, my lord, here I find one small judgment. Kindly see, I think my lord will not have it. My lord, I read this from in the comment section, my lord, I find this. A stereotype statement of non-availability of any public witnesses will not be sufficient, particularly when at the relevant time it was not difficult to procure the services of public witness. Sadhu Singh versus State of Punjab, 1997, 3 crimes, 55 PH, Punjab and Haryana. So here that means, they have never made an endeavor. So therefore, the requirement under section 27 of the Evidence Act has not been met, my lord.
The search was from a jungle, allegedly. From search and recovery. Jungle. But actually,
Within the
the
vicinity.
principles should be applicable, but section 100 pertains to closed spaces.
Yes.
So something like house or enclosed spaces. But anyway, the principles may be applicable. Principles should be applicable.
I'm also getting enlightened, my lord.
No,
Someone please write this. Sadhu, Sadhu Singh. You have written. My lord, I will provide this judgment also and also indicate the paragraph. Now, my lord, the second limb of argument which I want to start is yes, technical issue, my lord, just I'm correcting it. Now, my lord, violation of section 173 CRPC, that is non-forwarding of the case, that is probably because, like, my lord, I'm making this submission on the basis of the paper books and the records available with me, my lord. So kindly on this perspective, I'm making this argument. Now, my lords, to my mind, if I have to make a respectful submission, the impugned judgment and order of conviction dated 23/1/2024 passed by learned session Judge Bomjila is not sustainable for the reasons that IO has failed to forward the case diary containing statement of accused and witness recorded under 161. I think, my lord, if this is subject to correction, my lord, subject to correction if it is available in the thing 161. To the court below, along with the police report in gross violation of mandatory provisions of 173(5), my lord. Read with 172 CRPC. These vital documents are not even part of the paper book, which their lordships can discern out from the index of the paper books, thereby vitiating the entire trial proceedings as held in case of State of Punjab, Murarika judgment date of paragraph 8.
For the TCR, Mr. Tado, he is submitting that there is no available, the 161 are also not available. Probability that in paper book, it may not be available.
Yes.
Because it is under that context.
Correct.
But
161 is not provided with the problem.
generally,
Yeah, generally, my lord, it is not there.
but do you know whether it is available in the TCR?
Yes.
TCR means because
Yes,
it is a part of the CD also.
Correct, correct, my lord.
Then
Yes, Dad.
just go through and submit up this before, after that. Okay.
Correct. It's just, I indicate the paragraph, my lord, so to shorten the time, my lord. The paragraph 8, my lord, will indicate.
Yes.
Or paragraph 8. Now, my lord, if this is not complied with, non-compliance would mean, my lord, denial of appellant of fundamental right to fair trial granted under Article 21, my lord. So therefore, my lord, that if my lord remember that Zahira case, Best Bakery 2006, there where he was convicted also. I'm relying on that also, paragraph 37, 38, and 39. Oh, you give me that copy also. Huh. Well, I'm indicating the paragraph here. Well, my friends would also like to take some time for their argument, Milord. My lord, I request my lords to kindly have a visit on paragraph 40. I'm indicating. My lord has seen para 40 after G, my lord. After G, 1, 2, 3, fourth line. Para 40.
Paragraph 14.
40 G after G, fourth line. Doubts are raised about the roles of investigation agencies. My lord. Consequences of defective investigation have been.
You're in paragraph 14.
Para 40, my lord.
Last line.
40.
Oh, 40.
Sorry, my lord.
Yes.
No, these are also there. No, but doubts are raised about the roles of investigation agencies. The consequences of defective investigation have been elaborated in the Dhanraj Singh versus State of Punjab. It was observed. So the paragraph is quoted. In the case of a defective investigation, the court has to be circumspect in evaluating the evidence, but it would not be right in acquitting accused solely on account of defect. To do so would tantamount to playing into the hands of investigating officer if the investigation is designedly defective. Now this para 6 in the so and so it was held that if the lapse or omission is committed by the investigating agency or because of negligence, the prosecution evidence is required to be examined before such omissions to find out whether the said evidence is reliable or not. The contaminated conduct of officials should not stand in the way of evaluating the evidence by the court. Otherwise, the designed mischief would be perpetuated and justice would be denied to the complainant. As was observed in Ram Bihari Yadav versus so-and-so state of Bihar, if primary is given to such design or negligent investigation to the omission or lapse by perfunctory investigations or omission, the faith and confidence of the people would be shaken not only in the law enforcing agency, but also in the administration of justice. So then there we have also indicate the paragraph. Which paragraph? My lord will also mark this paragraph, my lord. Already reply. Well, but the rest of para I will not read, my lord, because I don't want to waste that time. My lord, the important thing, my lord, because of the defective investigations and all those things, then it violates the rights of the petitioner, appellant, convict appellant of right to fair trial as enunciated in Maneka Gandhi. My lord, may I give the citations? I'll not place it, my lord, it's too big. My lord, the Maneka Gandhi judgment is 1978, my lord. My lord will have to take some pain to write down. 1978, 1 SSC, page 248, paragraph 7 and 8, my lord. And it's okay. Copies, my lord, copies are here. I think my brothers, they have printed. Now, my lord, just I have indicated the paragraph. Now, my lord, the
Staple and the rest. Ulai dua please. Ini kita ulai dua, kita mau tu beda. Step please. Yes.
My lord, the third ground, which I am putting forward, my lord, is on the question that can a charge sheet be filed by a retired police officer? To my mind, my lord, if it is be the case so, ground B, then it is void ab initio. The trial, the cognizance, that means at the committal stage, my lord, 208, 209, my lord, and then it falls, my lord. Then the cognizance itself would not be sustainable. What I understand, my lord, after reading this, my lord. My lord has seen. Now, my lord will kindly come to para 21, my lord, page 81 of the impugned conviction order.
Para?
Para 21, my lord.
21.
Page 12, internal,
Yes.
and page 81, my lord. Para 21, PW8. Sri Bhanjan Rijiju, during his further examination, he deposed that after his retirement, he was called by OCPS Nafra and asked him to sign the charge sheet as investigation of the same was conducting by him before his retirement. Accordingly, he has put his signature and charge sheet was forwarded by the OC. He exhibited the charge sheet so and so. Kindly mark this. After retirement, my lord. Now, kindly come to para 39, my lord. 29.
Yes.
Para 29 is the PW 15, my lord. Laxman Sarma. The first line says he is the first IO, my lord. Now, kindly come to the cross examination on the para 30. That is at page 86, my lord.
29.
Para 29 and 30, my lord. Para 29, Laxman Sarma says he is the first IO, the first line. Now, in para 30, my lord, we'll read. It says, during cross-examination, my lord, as it, my lord.
Para 30 is in page
30, my lord, page 86. Paper book, page 86. My lord Pranjal, if I sit, I can. During cross-examination, he deposed that he has prepared the sketch map, but same is not in record. Kindly mark this, my lord. Number 2, my lord, he says, accused has surrendered before him and confessed the crime. Then thereafter, what he says, he has not forwarded the accused person to magistrate for recording of confessional statement. He has not prepared disclosure memo, my lord. That's what I am repeatedly saying, my lord. Disclosure memo, though the accused lead him to recovery of weapon of offense. So therefore, my lord, the rigor of section 24, 25, 26, 27 will come of the Evidence Act. And my lord, it will go up to section 114A of the Evidence Act, my lord. So therefore, the conviction based on such conduct and investigation cannot be sustained, my lord. Now, my lord, kindly see, for recording of the confessional statement, he has not prepared disclosure memo, though the accused lead him to recovery of weapon of offense. There was no independent witness. My lord, I am still harping and I am on my scheme of my argument, my lord, on the question of law as well. There was no independent person available except the police person at the time of recovery. He has not found the pallets. My lord will kindly mark this. I'm looking at PW. Where is that? My lord, here I just kindly see, he has not found the pallet, my lord. Now then, how a person is killed? Here, my lord, I'll indulge my lord to this particular piece. My lord, kindly come to the deposition of PW12, page 57. My lord, interestingly, this, my lord, the PW12 is the owner of the gun, and he, my lord, he appears before the court, the trial court made. Huh? PW12 is the person who kept the gun, and thereafter PW13 is the owner of the gun. My lord will kindly come to page 57.
57.
57 of the paper. Now this is the deposition. Is he Liki Sange? So and so. He's the owner of the gun. Okay. Well, this PW12 is the person who has taken gun from PW13, Miller. And how this gun has been kept and whom he has given has not disclosed, Miller. PW12. My lord, before this, kindly come to PW13 statement, then I can correct it, Miller. Well. It was recorded on 8th day of February 20. I am appearing in the case as I am the owner of the rifle, my lord. Bearing number so and so. My gun license was seized by the police in connection to this case. I am from Salang Blaze and under Lada Circle of East Kameng district. On occasion, I came to Nafra to purchase cow and bulls along with my relative, cousins, brother, in order to perform local rites. We purchased one cow and some same was brought back to Lada. However, on the way at the Jerigaon, we rested in the house of PW12. On reaching back to Lada, I realized that my rifle was not brought back. And after that, I made inquiry to PW12, my lord, is connecting, about my rifle over the telephone. He told me that the rifle was in his safe custody. I got suffering and I did not come to collect the rifle. In the meantime, the nationwide lockdown was declared. After a few months, I heard that an offense was committed from my rifle. I do not know the accused standing on the dock. Now he does not know. Then, my lord, his rifle, PW12 rifle, was kept by this man, my lord. PW12, my lord. He says, my lord, there's nothing, he says. I'm appearing in the case as a seizure witness of gun license number so and so. I witnessed the seize of the gun license from owner of the rifle so and so. Now defense declines nothing. Now, my lord, he says, PW13 says he's the owner of the gun. He forgot to take the gun along with him while going back to the blaze, and then gun was kept by him. Now, these, my lord, kindly see, my lord, then he is also the CW1. Another discrepancy, my lord, will find. CW1, please. CW1, you have put it. Just CW1, you have put it, no? Well, 67, page 67.
But he was present, the PW12 was present at the time of seizure of the
Seizure-
gun license only.
No, seizure of the gun license. That's why I'm saying seizure of the gun license. The person actually who was in possession of the gun, because PW13 left the gun at his home.
Yes, at his house,
Yes.
and it was kept, and then he said that it was.
Thereafter, Milord, see, I'm connecting one particular thing, Milord. Leki Sangi.
Now PW12 come as a court witness.
Now PW12 is coming as a court witness. How this can be possible, Milord? I do not know, but I have also done substantial trial. But
he was examined as a court witness also.
Court witness also.
PW1.
Yes, 12.
12.
But I have never came across, Milord, after 2 decades, Milord. I have also done substantial this thing.
One witness become two.
A person becoming 2 witness, one the court witness and another as a prosecution witness, Milord. डॉक्टर वाला कौन सा था? Page 58. हाँ, अभी डॉक्टर वाला.
But before examining him as a court witness, there must be some order.
I do not
Why?
know.
I'm also not aware whether there was any order, because you see, he was the person before. I mean, with whom the gun was kept, or gun was he kept the gun.
Correct, my
So
lord.
those things were not brought out while examining him as a PW12.
Correct.
So that may be the one reason why he was examined at the CW. But yes, there's a defect in these things. He could have, examined as a further.
Either one, my lord.
Yes.
Either court witness or if not the prosecution witness. Because a
Yes,
person,
that is
under
the
Evidence Act definition also, my lord, a person cannot be a witness for two purposes.
Yes, that is there. But the question is that PW12 could have been examined as a, suppose further with examination could have been, recorded.
Now, my lord, suppose.
But he was examined subsequently as a CW1.
CW. Now, therefore, my lord, he has not disclosed deliberately where the gun. He hided the actual fact, my lord.
Where?
In
CW1.
50, huh?
57.
PW12. He has not disclosed the actual fact before the honorable court at the time of trial. At the time of deposition, my lord. Kindly see these contradictions. Something, it is not a hearsay or anything plain in a plain language we say. Now, my lord, see. Now I am doubting, my lord. Since the police says that there was no independent witness in this case at the time of seizure of the gun, and recovery was done after some days. Now here, my lord, and then at the same time, my lord, in the channel, and the doctor, my lord, prosecution witness 14 says, I'm connecting very important point, my lord. Kindly come to page 59, my lord. My lord, kindly see. So therefore, I am doubting probably PW12, my lord, who is also CW1, might be the culprit in this case. And these, my lord, I can establish from page number 59, the deposition of the doctor, PW14. My lord, kindly, who has done the post-mortem, my lord, kindly come to the second paragraph straight, my lord. During examinations, I have found one entry wound of bullet on the right upper back of the deceased, measuring about 7 into 7 cm. There was swelling, my lord will kindly mark this. There was swelling surrounding the entry wound. The bullet entered into the body at 70 degrees towards downside. There was exist wound at the lower part of the midline of the lower chest. The wound is measuring by 3 into 1.5 cm. During internal examination, found that there was no congestion on the right. My lord, it's very difficult to pronounce in medical language. Pleury or lungs. There was puncture. There was puncture on the right lung measuring 3 into 3 cm. My lord, this is very important from this line. Bruise over forehead, my lord. Hammer, trauma below right, lower lip, a small cut injury on left eyes. And this has not recorded by the police. So therefore, my lord,
at the time of examination,
at the time of examination also they have not disclosed it at the position, my lord. So therefore, my lord, kindly see, there was a fighting. If that person has a motive, and my lord, the police in their deposition and the cross also, they have said there was no motive, my lord. If there is no motive, then kindly see, if a person has to shoot somebody, he will directly shoot. So there was a fight before. There was a fight. And my lord, see if according to Dr. Milord, in the first line of the second paragraph, it says, I have found one entry wound of bullet on the right upper back. From here, not from the front. Meaning thereby I had no role in this, my lord. I'll come to that. I have a ground on this also, my lord.
3:30 minute break होगा. That's the transfer. আপনার তো এখন লিস্টিং হবে লাগবে না.
Ground 3 mein bro. Now, my lord, kindly see, as I have already demonstrated. Now, my lord, kindly see, stands conclusively now. It stands conclusively admitted that a charge sheet was signed and forwarded by an individual who, my lord, at relevant time was no longer a police officer within the meaning of Chapter 12 CRPC. Now Section 173(2), my lord, may seek any of the court explicitly provides, my lord. Here it provides, as soon as it is completed, the officer in charge of the police station shall forward to a magistrate empowered to take cognizance of the offence on a police report, a report in the form prescribed by the state government. This provision is mandatory and personal in nature. It vests the statutory duty solely in a serving police officer in charge and does not envisage either delegation or post-retirement confirmation of such authority. Well, of course, there are some judgments which I will place, my lord. Now, my lord, this kindly see from 156 CRPC onwards, my lord. 156 CRPC onwards, my lord. The power to investigate on in a cognizable case, my lord. My lord, the act of, to my mind, my lord, the act of PW8 in signing and submitting the charge sheet after retirement is not a mere procedural irregularity, my lord. It is not a mere procedural irregularity. When the act, particularly, my lord, 173(2) clearly says that it must be a serving police officer, my lord.
Which section?
Section 173, my lord. 2. Yes, sir.
Okay.
One 173(2). To as soon as it is completed, the officer in charge of the police station shall forward to a magistrate empowered to take cognizance of the offence on the police report, a report in the form prescribed by the state government stating so and so. Then kindly come to subsection 5, my lord. These are all contains and everything. Subsection 5, 173. When such report is in respect of the case to which sections 170 applies, the police officer shall forward to the magistrate along with the report all documents or relevant extract thereof on which the prosecution proposes to rely, other than those already sent to the magistrate during investigation. Now, a person has seized, my lord, to be an officer of the police. How he assumed this? Because, my lord, it is in our legal parlance, my lord, what I understand is, if the acts provide you to do things in a particular manner, you must do in that manner only. If you do oppose it, then is void ab initio, my lord. Then see the statement, my lord, kindly see, extract B, the statement recorded under section 161 of all the person whom the prosecution proposed to the examination as its witnesses. So, my lord, obviously, my lord has seen now there are perfect defect in the investigation and the procedural thing, my lord. So, therefore, my lord, what I understand, my lord, in my lord, I already have seen, my lord, I will not say anything, my lord. Paragraph 21, my lord, page 12, internal page, my lord, that which paper book, my lord, kindly see page 81, my lord, where the learned district judge has categorically recorded, my lord. But learned judge has recorded himself categorically admission of PW8, where Sri Panjam Riju, a retired sub-inspector of police, after his retirement, he was called by the police officer in charge of Nafra police station and asked to sign the charge sheet as he had investigated the case prior to superannuation. It is therefore an admitted fact that at the time of signing and submitting the charge sheet by PW8 was no longer in service and consequently lacked an statutory authority under this court. Now, even in this PW8 testimony in paper book 52, page 52, my lord, and PW 15, paper book page 61 and 63. And both of them, my lord, unequivocally confirm that charge sheet was signed post-retirement. And significantly, my lord, PW 15, Sri Lakshman Sharma, he also deposed that he was the first investigating officer who had prepared the sketch map, now missing from the record, my lord. Kindly see in this the position. It is missing from his. 63 will be relevant, page 63 in the paper book. Yes. 63, my lord. Now missing, my lord. That means all the vital documents, my lord, had gone missing from the records, my lord. Now, when I refer to, my lord, section 173, subsection 2, to me, my lord, this provision is mandatory and personal in nature because it vests the statutory duty solely in a serving officer in charge and does not envisage either delegation or post-retirement continuation of such statutory authority. Now, kindly see, upon retirement, a police officer loses all statutory capacity. He loses under the code, my lord. And he no longer has the power under section 156, my lord, to investigate, nor under section 173 to forward the charge sheet, my lord, or the reports. And he becomes, my lord.
But one question, whether he prepared the charge sheet or it was remained to be, I mean, it was not signed by him, but it was prepared the charge sheet earlier.
No.
And then
No, the position is very clear. He was called by the police officer, OC Nafra police station, to sign the charge. So therefore, this VCS, my lord,
He had prepared.
prepared. That means he has prepared. Therefore, he has prepared, my lord. So thereby, under this, cognizance cannot be taken, my lord, in 190. The process starts from there. So therefore, my lord, this is fatal. Absolutely fatal, my lord. Because, my lord, it is fundamentally nullity, my lord. Nullity. Nullity in the sense, my lord, the charge sheet is the very foundation upon which cognizance is taken.
And other materials.
Other materials.
That is true, but we have to see the law also, the
Correct.
governing case law, that whether that is undoubtedly an infirmity, but whether that would be, per se fatal or it will be subject to prejudice.
No, therefore, if that, I have authority on that. If that foundation is void, then entire prosecution collapse. Because the act is performed by a person lacking jurisdiction, my lord. Because he has drafted, he has prepared the charge sheet. My lord, that Rasibut ka judgment, hai? Kindly give me that. I have not indicated the paragraph. Paragraph 9.
In a 482 matter, maybe. Certainly.
Correct.
In a trial, full trial.
In a full. My lord, see what happens. My lord, when we go into the detail, my lord, I have indicated the paragraph, my lord. Para 8 and 9. 9. Para 9, my lord. It says, my lord, it's an old judgment, my lord. Laid down that where an investigation is conducted in violation of mandatory provisions or by an officer lacking authority, any cognizance taken on such a report is without jurisdiction. The ratio decidendi clearly established that an investigation or report by a person without lawful authority vicious proceeding and defect goes to the root of the cause. Now, my lord, kindly have this 465, my lord.
This para?
Para 9, my lord.
9.
I have indicated, my lord, just I have read out the propositions. My lord, kindly have 465.
Yeah.
My lord, that failure of justice which my lord Yes. I will come to that. I will give. In the meantime, my lord, kindly see whether it is a defect can be cured or not. I don't think it is curable, my lord. Or defect, 465, my lord. We are old school, my lord. My lords also. I am from the same school of the CRPC only. The BNSS come into and
Yes, 465.
yes, sir. My lord, kindly see 465 CRPC. Finding or sentence when reversible by reason of error, omission, irregularity. Now, my lord, I have already seen a lot of irregularities in this investigations and the trial as well. My lord, I'll just read. Subject to the provisions herein before, contain no finding, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation, or revision on account of any error, omission, or irregularity in the complaint, summons, warrant, proclamation, order, judgment. My lord, here we are concerning with the word judgment, or the other proceeding before or during trial or in inquiry or other proceeding under this court, or any error or irregularity in any sanction for the prosecution, unless in the opinion of the court that the failure of justice, which my lord Pranjal has asked me, where if you can show me the failure of justice has in fact been occasioned thereby. In determining whether any error, omission, or irregularity in any proceeding under this code, or any error or irregularity in any sanction for the prosecution or occasion a failure of justice, the court shall have regard to the fact whether the objection could and should have been raised at an earlier stage in the proceedings. Here, my lord, I respectfully agree that from the record, I could not find any objection raised at the early stage, my lord. So, my lord, I am relying for the 2002 SSC, page 5. I have indicated the paragraph also. No, it's a failure of justice, my lord. That's 2024 INSC 95 you give me. Well, this, I have one more judgment on this. 2024 INSC CBI versus Jagat. But this latest judgment is there. CBI Jagat Ram, Central Bureau of Investigation. Correct. Itu didi. Itu pera golpi, pera 9 over. It should be 7 and 9, no worries. Well, this was relating to the PC Act, but then the sanction was not granted in accordance with the mandate of law under section 19. So then what had happened, can such cure be defect? The court says no. My lord, sorry, my lord, also para 12, my lord, para 12, kindly indicate para 12 also. Yeah, Lordship Justice Gogoi is also explained what is failure of justice, my lord, in this. My lord, para 9. Apart from the clear statutory prescription of section 19, that is PC Act, because there is part of criminal trial as well. As informed by the relevant court proceedings, the High Court has also lost sight of section 465 of the Code of Criminal Procedure, which provides that a sentence or an order passed by the court of competent jurisdiction shall not be reversed or altered by the court of appeal, confirmation or reversal on account of any error or irregularity in any sanction for the prosecution, unless in the opinion of the court a failure of justice. So this we need not to read, my lord. Kindly come to 12, my lord. This is how Justice Gogoi has explained, as he then has explained this position in the state of Bihar Supreme, my lord. My lord, kindly see next page, my lord, page 8. para 6, they have quoted this judgment. In a situation where under both the enactments, any error, omission, or irregularity in the sanction, which would also include the competence of authority to grant sanction, does not vitiate the eventual conclusion in the trial, including the conviction and sentence, unless, of course, a failure of justice has occurred. So, my lord, I have demonstrated how the failure of justice has been committed. It is difficult to see at how intermediate stage a criminal prosecution can be nullified or interdicted on account of any such error, omission, or irregularity in the sanction order without arriving at the satisfaction that a failure of justice has also been occasions. This is what has been decided. Now, para 14 in this same, merely because there is any omission or irregularity in the matter of according sanction that does not affect the validity of the proceeding unless the court records the satisfaction that such error, omissions, or irregularity has resulted in failure of justice. What is the irregularity here? As my lord has kindly seen the statement of PW 8, PW 50. And kindly see, my lord, the deposition of PW 12, CW 1, and PW 14. The bullet was not at all recovered. And PW 16, my lord, is very interesting, my lord. The bullet, my lord, which was fired and supposed to be killed, and supposedly has killed the person, was even not sent for examination. My lord, kindly see. I saw you.
Yes, I've seen that.
My lord has seen. Even the doctor finding is also there. My lord, kindly see. May I request, my lord, kindly come to page 64 for a moment, my lord. No, uska depositions kahan tha? My lord, kindly see that cross, my lord, page 66 of the expert Arun Kumar Pal, the ballistic expert, my lord. Kindly mark this. It is a fact that I have received 5 unfired ammunitions of 315-inch 8 mm for examination. I have not received the bullet which killed the disease for examinations. Now, if this is the case, so who has killed? It is not me, my lord. This is the major defect of investigations.
Nobody has seen.
Nobody has seen, my lord. I said there was no eyewitness at all.
Only assumption.
On assumption and presumption, how a person can be convicted, my lord?
So, he was one and any other, he is PW 16.
16, my lord. If, my lord, say for example, if that particular
He
gun
was the only one expert who is explaining.
and he has categorically said, my lord, even the doctor also PW 14, my lord, he has also said that he has not found any bullet.
Pellets.
Pellets. Sorry, my lord. I missed it. Thank you for correction, my lord.
Page 60.
Page 60. PW 14, my lord, kindly see. The doctor has also seen.
Page 60.
Now, this is prima facie a case, my lord.
Page 60.
How he was killed. And then, my lord, kindly connect the scene that PW 12.
For examination. But it's not part of the bullet goes to the examination.
This is, my lord, absolutely in conformity with the doctor. Page 60, my lord will say. Page 60. And it is absolutely corroborating, my lord. Finding of the doctor, my lord, kindly see. I have line 2, my lord, in the cross. During examination, the injury was found to be 24 hours old. I have not reflected about the age of injury in PME report. During my examination, I have not found any pellet inside the body. And this is absolutely corroborating with page 66 by the ballistic expert.
In examination in chief, he has said that, you're right, I mean, he's, in examination in chief, he has said puncture of right lung due to bullet injury. But since he has not found pellets, therefore he is saying that the possibility of a non-bullet injury is also open. That is what he's trying to
Yeah,
say.
that is open, my lord, for the reasons that the post-mortem report, my lord, has seen. There was a bruise. Where is that piece? Kindly see. My lord, kindly turn back to page 59.
Yes, yes, perhaps.
My lord, we'll see the second paragraph, my lord, last two lines. Hmm. Hmm. And then let us read together this paragraph 2 at page 59. my lord. During examination, I found one entry wounds of bullet on the right upper back of the deceased measuring about 7 into 7 cm. That means the bullet was not there. And bullet is still inside, my lord. Now, my lord, kindly come to the second to last page. Bruises over forehead, hammer, trauma below right, lower lip, a small cut injury on left eyes, leads. There was fracture on right scapula, right bone of the upper back. But kindly see. So therefore, prima facie, my lord, the prosecution number witness 12, who has received gun from the prosecution witness 13, my lord, has never made any disclosure whether he has given the gun or not to the convict, my lord. This is corroborating, my lord. And this has completely...
13 never gave his gun to the accused.
Never.
It was the PW 12 under whose custody the gun was there.
Yes, ma'am. Then he ought to have made a disclosure when he was making a deposition before the court, saying that I have given the gun to him. This link is not there, my lord. So therefore, my lord,
as you know, prosecution.
We had one problem. Actually, he has to pronounce one judgment.
Okay.
My brother has to pronounce one judgment. Maybe it may be continued at 3:30, 4 can be. Up to 4 we can hear, otherwise.
Yeah.
Or then
I can.
Then next I'll indicate all those things, my other grounds. Then I will reflect in my written argument, and then for 10-20 minutes they can make submission on.
How can you say 10-20 minutes?
No, that depends on them.
He is giving you only 10 to 20 minutes. Because during that time also you also see Perus the TCR and just let us know regarding the recording of 161 or 164, because 161 or definitely is not available in here. So you can peruse the record.
From it's clear that there was no request for 164 statement.
No, 164 was not there. 164 was not there. 161. Wait.
But the staff could not find the TCR also. TCR is not.
TCR is not
161 must be there. Must be.
TCR 9 again.
So you went to the office and
Well, that's why, my lord, I made a submission
TCR
subject to correction by their lords.
We have received because paper book was prepared. Na?
because without
How prepare will TCR, how paper book will be prepared? There is
No, my lord, that's why 161, 164 should be brought in the paper book, my lord. Although it is not a public document, my lord.
164 may not be there, but 161 statements must be there.
Must be there, my lord.
Without 161, the defense at the time of trial would have been.
Yeah, because otherwise, my lord,
in cross-examination.
yes. Otherwise, my lord, otherwise that 162 objective will be failed.
It would be there in the case diary, I think.
Anyway, you can continue up to 4, then
Yes.
my brother will.
Correct. Now, my lord, now this subject which I was dealing was, my lord, there's a broken chain of custody and contradiction between medical and ballistic evidence. So kindly have this point only. My lord, I am very sure, my lord, it is, my lord, kindly see just my concluding submission on this particular point. The argument which I have advanced is, my lord, the ground for broken chain of custody and contradictions between medical and ballistic evidence, forensic evidence unreliable. Now that the conviction cannot be. Well, kindly see at page 32. Para 32, page 88, my lord.
Page 88.
Page 88. It's very convenient technologically, my lord.
Yes. 32.
Para 30. During cross-examination, my lord, kindly say. During cross-examination, he deposed that he has received 5 unfired ammunition of so-and-so. He has not received the bullet which killed the deceased for examination. This part, my lord, I want to rely on, my lord. Then kindly see that medical, my lord, that medical doctor, PW14, my lord, will find at page 39, internal page, para 39, my lord, page 91. 59 and 60 of the paper book. This is very fine. Page 91.
Yes.
It is there, huh?
Para 39.
Yes. Para 30, paper page.
With 91, para 39.
Yes, yes.
No, it's okay. Just you.
No bullet was recovered. No bullet was recovered, he says. But kindly come to line. This line 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11th line, my lord.
Last from 4.
Last from 4, my lord. During his cross-examination, he deposed that he has not found any pellets, and it may be possible that puncture wound may be committed by any other weapon. PW14 has exhibited dead body memos, and so I am not onto that, my lord. Now, therefore, my lord, kindly see, if PW15 admitted that following the above critical omissions in this, no pellet was found. Even the doctor also says nothing was found. Did not seize the cloth of the accused person. He has not seized also. Then gunshot residue evidence lost. In that case, yes, evidence is lost. Did not forward the firearm for fingerprint test. Even the fingerprint test was also not mentioned in this. Now kindly see, so if it is not done, no link between accused and the weapon. Because that fingerprint, my lord, has to be tested. No fingerprint was tested. No sample has been collected. Now you cannot link me. No link between accused and the weapon. Because did not annex his forwarding letter when sending the exhibition to the forensic science laboratory. Exhibits were once written in this, my lord will find in this. Exhibits were once written and later resent again. It was resent again. So therefore, my lord, chain of custody is broken. A sketch map, my lord, claim to be prepared is missing from the record, my lord. No disclosure memo prepared, no arrest memo prepared, and no independent witness associated during search and seizure, my lord. All police personnel. So if I have to make a submission, my lord, as such lack of a verified chain of custody renders forensic opinion unreliable and inadmissible. 1. 2, my lord, such omission breaks the evidentiary chain and render the forensic evidence unreliable. The FSL report matching cartridges to rifle has no evidentiary value because chain of custody broken, exhibits returned and resent, fatal bullets never examined, no direct link to the death. No forwarding letter cannot verify what was actually sent. No fingerprints on weapon, no link to accused, and no GSR testing on accused clothes, opportunity lost. That's what my submission is, my lord. So, my lord, coupled with the medical officer's statement that no bullet was recovered, the prosecution theory collapsed. At the first sight, my lord, if we see, the prosecution cannot prove beyond reasonable doubt that the recovered rifle was the murder weapon, my lord. It was not. The accused fired the weapon or the weapon was handled by the accused. So therefore, my lord, the is incomplete, unreliable, broken chain, custody is missing, critical link, cannot establish guilt beyond reasonable doubt. Well, there are Panchil principle is already there, my lord. Way back in 1984, it was established. Unless if you don't do this, you cannot convict a person in this manner, my lord. Now, my lord, the fifth limb of my argument in this case is, my lord, absence of motive expressly admitted by the prosecution, my lord. Now, my lord, if rightly recall, my lord, kindly see this, the cross and examination in chief of the PW15. He has categorically said, my lord, that there was no motive. Just I demonstrate. Here, I will rely this Babu versus Kerala judgment, my lord. I'll just indicate the paragraph, my lord. My absence of the ground. My lord, kindly see at page PW15, paper book 61, 63, my lord. Yes, I indicate the paper. 61, 63. Again, we come back. He has clearly said in the depositions. My lord, kindly 63 is there. 63, I'll indicate the line, my lord. Cross me. 1, 2, 3, 4, 5, 6. 6 line below, my lord. 6, 7, no? 7. 7, 8 line, my lord. Starting from 8 line. I have not found the motive of offense. Now, what else you require, my lord? I said, I have not found the motive. Now, despite this, my lord, it is because if this is to be taken on board, my lord, no motive was found during investigation. Then the accused and the deceased were friends. And then, my lord, presumably, my lord, or the fact, if as it is exists, my lord, then there was no enmity between them. Now, kindly see the deposition of PW15, my lord, page 49. PW5. Similarly stated that he do not know of any prior enmity between the accused and the deceased, my lord. And the categorical statement by the investigating officer himself nullifies the trial court's speculative assumption that the act was motivated by frustration or the anger arising from a quarantine restrictions. Hopefully, now my lord has read the fact in a proper perspective, lord. Now, my lord, kindly see, despite the express admission by PW15, my lord, the learned session judge in paragraph 35, my lord, paper book 89, my lord. Kindly take out. They speculated that the act was motivated by frustration or anger arising from quarantine restrictions. This finding is not based on any evidence, my lord. Rather, opposite to the evidence available before him. And it is contradicted by the investigating officer's testimony. It is, my lord, to my mind, is pure conjecture and surmise. and impermissible in criminal law. This should not happen. Now the Honorable Supreme Court, what it says in Babu versus Kerala, paragraph 23, I am reading, I will provide the judgment. Held that motive must be proved by credible evidence not set on the conjecture or speculation. In a case based entirely on circumstantial evidence, the absence of proof motive significantly weakens the prosecution case and makes the chain of circumstances incomplete. The finding of motive by the learned session judge is thus wholly unrealistic, contrary to express admission of investigation officer, not supported by any criminal evidence. Well, just the judgment is not there. My lord, kindly, this Babu versus State of Kerala, 2010, my lord, 9 SSC, page 189, my lord, paragraph 23. Huh?
Page?
25.
Page?
My lord, page is 189, paragraph 23 and 25. my lord. I'll not ask much, my lord. Only I have left with another 2-3 grounds. Small grounds, I'll finish it. My lord, that kindly see, I have already asked, my lord. Kindly make it one paragraph only, one ground. Procedural violation under section 100 and 165 and 172, which I have already done it, my lord. I'll just we only to recast on this particular point, my lord. Admittedly, my lord, records are missing. One, my lord. The disclosure statement never prepared here in this point, my lord. Then arrest memo never prepared. Sketch map. Now PW15 claimed to prepare but not on record, my lord. For forwarding letter to FSL not annexed, my lord. It is not there in the record, my lord. Independent witness certificate is not there in this case, my lord. So then, my lord, and proper seizure memos. Therefore, such procedural lapses make the investigation unreliable and cannot be brushed aside as a mere irregularity, my lord. So therefore, my lord, that which I have reiterated on the proposition that procedural violation under 100, 165 and 172 CRPC, my lord. There's one ground I am because my lord, what I understand, my lord, the procedural infractions, my lord, destroy the legitimacy of the prosecution. Yes. Complete absence of mandatory procedural, my lord, compliance, what I understand, destroy legitimacy and credibility of investigations, renders evidence unreliable, makes conviction unsafe, and violates fundamental safeguards designed to ensure fairness, my lord. So that's what I'm trying to impress, my lord. Now, there, madam, electronic voice is also there, voice recording. And my lord, that alibi, plea of alibi, only 2 grounds left, my lord. Then the rest I'll give in the written form, my lord. Now, my lord, ground 7, my lord, ground 7, my lord, which I assail this impugned judgment is on weak and unreliable voice identification. Now see, the learned trial court in paragraph 43, my lord, kindly see page 26, paper book 95, 96, my lord. Nalin. This is, my lord, regarding identification of the accused voice by PW3. Paper book, my lord, will find at page 47 and PW7, paper book 51. Who claimed to have heard him shout, "Marega bola hai to marega." That means in translation, my lord, if I said he will die, he will die. And form one of the basis for conviction.
This is the sole basis for conviction.
This is the sole basis for conviction as well. However, my lord, what I understand is this evidence is inherently weak and unreliable.
This has been not.
because they have become hostile, my lord. Both of prosecution witness in their deposition, they have become hostile. And in spite of that hostility, the learned trial court goes on convicting. Well, see, for even if this marega bola hai to marega, that means if I said he will die, he will die. And that means form one of the basis for conviction. However, if this evidences is however, to me, my lord, this evidence is inherently weak, my lord, and unreliable. Because the circumstances where we see, my lord, see the circumventing situation and the circumstances, my lord, where nighttime incident, my lord, darkness, commotions, distance from accused, no direct visibility, and mistaking a voice is highly probable, my lord. Now, kindly see, my lord, this is how, my lord, significantly, my lord, PW1, my lord, kindly see, PW1, my lord.
Voice sample test.
No, this has not, voice sample has also not been tested, my lord.
Only putting on
Hmm.
the statement.
My lord, see, in paperwork 44, okay. Admitted during cross-examination, he did not see the actual firing and the voice he heard could be of some other person. But I'm saying that it is a fact that in cross, my lord, kindly see, page 44. It is fact that there was no prayer of enmity between the deceased and the alleged accused. It is fact that I have only heard the sound of gunshot, but not the actual person who fired the shot. Clinching, my lord. It is fact that voice that I heard could be of some other person. It is a fact that the alleged accused might have carried a piece of stick instead of gun. It is a fact that I have only given my opinion rather than witnessing the incident with my own eyes. It may be fact that some other person might have fired the shot. So therefore, my lord, this statement is well fitting with the depositions of PW14 doctor, because it says a brushes. Had there been a gunshot, directly a person could have been killed. Then, my lord, the conduct of PW13, the owner of the gun, my lord, he has passed on gun to the PW12. And this PW12, my lord, kindly see, he becomes prosecution witness, number 12,
Deliberately not.
and deliberately has not disclosed. Because before the honorable court, as to an extent, that gun was in his possession, and whom he has given, he has not disclosed it. So therefore, my lord, complete chain of suspicion lies on this PW12, who is also the court witness 1, my lord. Because if you cannot say from where, after receiving the gun from PW13, my lord, I have given the gun to him. This has not been disclosed, my lord. Well, this is somewhere, my lord, I feel the ground number 7 also holds the field, my lord. My lord, this judgment, I think I have not. Jasbir Singh judgment, have you brought? Well, in any case, I have this judgment. I'll just play it. But I have not completed, because this is my draft, something point wise, which I will convert it in the night, night time. So, kindly see.
We'll do one thing. Thursday, we are having single bench.
Correct.
But this matter will be fixed.
Yes, ma'am.
At 2, it can be fixed, I think.
At 2.
Otherwise, it may not be complete. And Friday, I'm not in a position to hear the matter. So,
I'll just take another 5 minutes to finish off my grounds, and I place the line. Now, Malad, see, no, ground 7, I'll complete it, Malad. So, if this PW1, who says that he did not see the actual firing and the voice he heard could be of some other person, this admission, my lord, by a key prosecution witness demolishes the reliability of voice identifications. Yet, the learned trial court in paragraph 43 at page 26, internal page of the impugned judgment, my lord, place reliance on these inherently weak evidence and lead to the convictions. My lord, the judgment which I'm referring to is 2001 5 SCC. My lord, I will indicate the paragraph. I have just noted down the proposition.
5 SCC.
Yes, 2001 5 SCC, page 422.
Kindly tell the
That is Jasbir Singh versus Bipin Kumar Jaggi. My lord, that's also
Jasmeer Singh.
Jasbir Singh versus Bipin Kumar. Here, my lord, the Honorable Apex Court has discussed the inherent challenges and unreliability of voice identification, particularly in the circumstances of darkness and confusions. Voice identification without corroboration from other reliable agents cannot form the sole basis of conviction. That is the proposition which I'm relying on this, my lord. So therefore, my lord, I find that the voice identification evidence is inherently unreliable, contradicted by prosecution's own statement, PW1, my lord, made in a circumstances of poor visibility, my lord, that my lord has seen from the record itself, and even not corroborated by any other evidences, my lord. Now the ground 8, my lord, just I think I am on the verge of finishing. Now, my lord, so far we have seen now incomplete chain of circumstances. I am arguing on that line, my lord. Failure of Pencil test, which I was referring to, my lord. Failure of Pencil test, my lord. My lord is aware that 1984 for SSC, Birdi Chand Sarda versus State of Maharashtra, my lord, I am just giving the citation, 1984 for SSC, my lord. Page 116. No, I have not. You have given me the latest judgment also. Well, this is circumstantial evidences. It is latest judgment, Lord, 2025 INC 1269, Lord, latest judgment. It was decided on 29/10/2025. In the paragraph. Well, just I am indicating this paragraph. Well, just 17. I'll not read just. Well, paragraph 17, 24, 25, 27, 32, and 33. Lord. I think in the heading, Lord. Madam, important point was, Madam, mother, in absence of any forensic evidence, when there is no eyewitness and the case is of circumstantial evidence, benefit would go to the accused, Lord. This is the proposition which I want to argue. This is why, because, my lord, kindly see, Madam, how this length in the present case, my lord.
Dipanga Datta was were also circulated with Dipanga.
Yes, my lord.
This was circulated.
This was circulated. Now, kindly see, my lord, in the proposition laid down in this judgment, how it covers my case is, my lord, for the first reason, my lord will note, number one link is broken is foundational document is broken because the charge sheet is filed by a retired officer, my lord. One. Number two, my lord, disclosure is broken. No disclosure statement and contradictory version, arrest versus surrender, my lord. Arrest versus surrender, my lord. Number three, my lord, how the chain is broken is here the recovery is broken, my lord. No independent witness. Recovery witness didn't see recovery and legally inadmissible under section 27. Number four, how the link is broken here. Crime link. Crime link is broken, my lord. Fatal bullet never examined. No forensic link between bullet that killed and the weapon and chain of custody, my lord. Number five, my lord, accused weapon link is broken. No finger test, no GSR test, and no physical evidence connecting accused to the weapon, my lord. Number six, my lord, the motive is not there. Motive is broken. IO admits no motive found and accused and deceased were friends. Number seven, my lord, the identification is broken. Only voice identification in darkness and PW1 admits voice could be of someone else, my lord. Now, number eight, my lord, investigation is broken, my lord. Number 8, the investigation is broken. Chain of custody, compromise and fatal bullet never examined, my lord. Number 9, my lord. Number 8, my lord. Investigation. Contradictory testimonies of IOs, my lord. PW8 and PW15, my lord. Critical documents missing and procedural safeguards violated, my lord. This is what I'm on. My lord, forensic now, the last chain, how it is broken is 9. Chain of custody, compromise and fatal bullet never examined. Number 10, my lord. Witness testimony is broken completely, my lord. Completely broken. Material contradictions. My lord, PW2, my lord, I just kindly mark this. PW2 turn hostile and improvement in testimony, my lord. That part, my lord, is there. My lord, because as such, in a case, my lord, what I respectfully submit is, based on circumstantial evidence, if any link in the chain of the circumstance is missing, the chain breaks and hypothesis of guilt cannot be said to have been established. When multiple links are broken, as in the present case, acquittal is mandatory. Benefit should be given, my lord. So, my lord, see, the settled proposition is law, proposition of law is that the circumstances, my lord, even if it is proved, are not inconsistent with innocence, my lord. Alternative reasonable hypothesis, my lord, are someone else committed the crime. Here, my lord, because the PW12, my lord, I have my own doubt, my lord. Because here, my lord, kindly see, someone else committed the crime to me, my lord. Accused was elsewhere, and, my lord, the alibi improperly rejected, which I have the last ground, my lord. Alibi was improperly rejected, my lord, because 313, he already denied everything, my lord. My lord will have the perusal of 313 statement also, my lord. So now can you see, boys was misidentified in darkness. Weapon recovered was not the mother weapon. And evidence, my lord, fabricated or planted. Nobody knows. When evidence is equally, my lord, compatible with the innocence and guilt, accused entitled to acquittal. So that is what the chain of circumstances is, my lord, I understand, manifestly is incomplete here. Is broken at the multiple critical points, my lord. 10 points I have given, my lord, indicated, is not consistent only with the guilt. Now, my lord, the last ground, which I am finishing it off. I'll take another 3 minutes, my lord, maybe 2 minutes. Well, which I said, my lord, the misinterpretation of alibi defense, my lord. Alibi defense. Kindly see, if I don't argue on this point, my lord, my purpose would be defeated. My lord, my lord, kindly see paper book page 68, my lord, DW1. 68, Kaka.
Please.
68, my lord.
68 of the paper.
The ground number 9.
Which is that?
हम जिपा को तो 2024 ना हाँ ये वाला well just to give you a moment 9 na misinterpretation of alibi testified that accused elsewhere at relevant point of time, my lord. Page 68 defense. Yes, 59 My resident is near to the resident of accused and we are brothers in relationship. Once accused was staying in his residence for 3 days, I supplied him rice and other. I stayed at his residence. I do not know about the fact of the case. I came to witness as I am related to the accused. When a cross declined, my lord. Kindly see page 69. These are all DW depositions. The same thing which they are saying. Now, from a my lord, DW say specifically, my lord, DW2, DW2 specifically mentioned being with the accused in June 2020. Though Malad mistakenly recorded as June 2002, but see, which appears to be a clerical error, Malad, that can always be taken care of. Now, this is very important, Malad. The trial court in paragraph 54 at page 36 and 37 of the impugned judgment dated so and so, paper book 105 and 106, Malad. Dismiss the alibi plea in a perfunctory manner, stating that DW1 and DW2 did not depose about the specific date of incident. 01/07/2020. But I think this approach, well, I understand this approach is overly technically and mechanical, Malad. Technical and mechanical, Malad, this approach. And it overlooks the essence of the alibi, Malad. Alibi. And the learned trial court, Malad, what I have noted is, have failed to consider the defense evidence in proper perspective and ignores context of weak prosecution case. This cannot, Malad. Malad, I would be relying this judgment on Dudnath Pandey versus State of UP, 1981, to SSC 166. Malad, this will come in the written, my lord may not take pain also. My lord, these judgments, everything will come in my written argument. I'll furnish on 5th, my lord, 6th, I think we are having. So, my lord, here the proposition is, which I want to argue is, my lord, the Supreme Court held that when the prosecution case is weak and not free from doubt, even an alibi which is not very convincing may tilt balance in favor of accused. The court was required to assess the overall calibrity of defense witnesses and the plausibility of the alibi in light of the weakness in the prosecution case, rather than dismissing it on technical grounds. Given the numerous fatal prosecution case, rather defects, void charge sheet, no valid recovery, no motive, no forensic link, fatal blade, unrivaled voice identification, the alibi gains significance and should have been considered more favorable. So, my lord, for today, all the grounds, my lord, I have taken. So then, my lord, I will come with my written argument with my closer thing, my lord. Closer finding I'll give where the defects are there. No, I'll finish it up.
Shiva, you put it on Thursday at 2 p.m.
Gotcha.
But the question is that Friday I'm not going to take the matters after 2 because I
understand.
So by Thursday, that's why even if we have single benches, my brother is also having single bench, but still then we are fixing at 2.
Okay.
So that it can be completed. Otherwise, if it remain uncompleted or if it is remain part-heard, then it will be another problem because constitutional ban with my brother may be a difficult position.
Correct.
So
When I understand.
try to finish it up by Thursday. Anyhow, you may also take more than 1 hour, maybe 1.5 hour also. And you don't repeat this thing because you're going to provide the written argument.
I'm not
And
going
that
to
part
repeat
we
it.
have already recorded your
Yes.
submission or the grounds which raised by you. So don't repeat and ask them, and then you just furnish the written argument, copy of the.
I will not make any submission, my lord.
only submission.
Only written submissions.
Okay.
On a tighter vein, they will get more than 20 minutes.
Yeah.
So apparently you have seen that 161 are available.
Yes.
Undoubtedly 164 may not be there or may not be there prior also for recording of 164, but 161 is there. And rest apart, you will submit. Heard Mr. Titara, the learned counsel for the appellant, and also heard Mr. G. Tado, the learned additional PP appearing on behalf of state respondent. And Miss, you are?
H. J. Ram.
MSH J. Ram, the learned counsel appearing for the respondent number 2. You are legal aid or?
Legal aid.
Legal aid counsel for the respondent number 2. Matter remains part heard. No, Thursday fix করে দিব at 2 p.m.
6.
Matter is parted. Release the matter on Thursday, Wednesday at 2 p.m.
লিখো ডেট লিখো
এইটো ইয়াতে থৈ দিব he is going to deliver one judgment
Oh,
and more from Oxford. Yes.
sorry my lord,
From the-
sorry for detaining
for the principal. No, it's okay. It's a 4 only. It's okay. রাম অক্সন আমার মুশকিল হয়ে গেছে শোনো go to the